Shri Arif Muhammad Khan, Justice Kurian Joseph, Shrimati Madhavi Goradia Diwan, Shri Asaduddin Owaisi, Shri Baijayant Jay Panda, Shri Faizan Mustafa. The most renowned speakers, the most acclaimed legal eagles, the most distinguished academicians, and the biggest newsmakers come together on the most esteemed stage. Watch the unmissable Ram Jethmalani Memorial Lecture only on Republic TV.
Good evening, ladies and gentlemen, and a warm welcome to all of you on the occasion of the third edition of the Ram Jethmalani Memorial Lecture Series. I'd like to begin by saying that it is a great honor for me personally and for the Republic Media Network to host this year's Ram Jethmalani Memorial Lecture. Mr. Ram Jethmalani, we all know, was a legend in the courtroom, and he was a great friend, a believer, and a supporter of the free media. And it is a matter of great pride for us at Republic, and I'm sure for our friends in the ITV network, to host and co-host this event in his honor. Ladies and gentlemen, Mr. Ram Jethmalani truly believed that a vibrant debate is at the core of every democratic and legislative process. His intellectual canvas was extremely diverse, and that's what made him who he was. He was not just India's foremost jurist, but also a great student of political science. Through his life, a student of diplomacy and foreign policy as well. Ladies and gentlemen, but at his core, some of who had the privilege to interact with him knew that he was a fierce nationalist. And his belief in nation first resonated throughout his illustrious career. Mr. Ram Jethmalani's fierce command of the law, which no one can question, and his sharp opinion on matters of national importance made him integral through his life to every debate in this country around law, legislation, and politics in his over 7 decades in public life. Which brings me to the subject of the lecture series today. A subject that I'm sure Mr. Jethmalani would have loved participating in himself. Ladies and gentlemen, the theme of this edition of the Ram Jethmalani Lecture Series in his memory is, quote, "Has the need for a uniform civil code become an imperative today?" This is a subject that intrigued Mr. Jethmalani. At some points, he raised doubts about the UCC, and at others, he urged the courts to look upon the constitutional position on the Uniform Civil Code to resolve matters. And he was aware, viewers, he was aware that it was a very contentious matter. But it was clear that he wanted a resolution to the issue of a Uniform Civil Code. He would have said, whatever it is, resolve it. I'm sure that's what he would have said. Today's panel and guests can perhaps be defined by 3 eyes on matters regarding constitutional law and the Uniform Civil Code. They are informed, involved, and very influential. And we are all conscious here that every word spoken here today on this platform will be making headlines, not just in the legal world, and we are aware that the nation is watching. But before we start it all today, I want to very warmly welcome Mr. Mahesh Jethmalani, an illustrious son of a very illustrious father and a renowned advocate now a very active parliamentarian, ladies and gentlemen, but most of all, and I feel very privileged to be able to say this over the years, someone who has become our personal friend. So I'd like to hand it over now to Mr. Mahesh Jethmalani. Mr. Jethmalani.
Thank you, Arnav. Ladies and gentlemen, it is with immense pride that I welcome all of you to this, the third edition of the Ram Jethmalani Memorial Lecture Series. It is a measure of the success and popularity of the lecture series that apart from NewsX, who have supported and encouraged this series from its inception, Republic TV, with its wide viewership, has this year chosen to broadcast the event live. We look forward to their continued participation in future. I thank Mr. Arnab Goswami and Mr. Kartikeya Sharma for their most vital support. This year, we are honored to have as our chief guest the newly elected Vice President of India, Shri Jagdeep Dhankarji, who I may add, rescheduled another program so that he could grace this event as chief guest. It is also pertinent to point out that he has been a distinguished member of the bar himself. I also welcome the Solicitor General, Shri Tushar Mehta, who, given his very, very close association with Shri Ram Jethmalani, will, I hope, be a perennial guest at this event. I welcome and thank profusely every one of our 6 very eminent guest speakers on the topic of today's discussion. All of them are distinguished servants of the nation, erudite, and uniquely qualified to speak on today's subject. They are outstanding speakers and undoubtedly passionate about their viewpoints. I have no doubt that their individual views, whether widely disparate or only nuanced in some differences, will be illuminating and thought-provoking. In keeping with the aims, ladies and gentlemen, of the lecture series, i.e., to have an informed discussion with diverse views on a burning topic of the day, this year's topic is, has the need for a uniform civil code become an imperative today? A brief background. With the nation reeling from the horrors of partition of 1947 and the Hindu-Muslim riots that ensued in its wake, the framers of our Constitution did not immediately opt for a uniform civil code, but left it to future generations in less turbulent times to frame such a code. Article 44 of our Constitution prescribed that the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. 38 years later, with no uniform civil code in sight, the Supreme Court in 1985, in the famous Shah Banu case, and in the words of the then Chief Justice, Y.V. Chandrachud, pronounced, Article 44 of our Constitution has remained a dead letter. There is no evidence of any official activity for framing a common civil code for the country. A common civil code will help the cause of national integration by removing disparate loyalties to laws which have conflicting ideologies. It is the state which is charged with the duty of securing a uniform civil code for the citizens of the country, and unquestionably, it has the legislative competence to do so. A beginning, it said, has to be made for if the Constitution is to have any meaning. Justice Chandrachud's words failed to evoke any response from successive governments since 1985. The biggest sufferer has been the cause of gender justice. It was left to Muslim women themselves to assert their rights. Shaira Banu challenged triple talaq in the Supreme Court successfully. But while divorce by triple talaq was invalidated, the ground reality was that Muslim women were left helpless in the matter of enforcement of their rights, which the Supreme Court recognized. Husbands did not maintain them or their children and contracted further marriages. The government ultimately had to step in to enforce the judgment of the Supreme Court and enacted the Muslim Women Protection of Rights on Marriage Act 2019. That legislation has had mixed success. Today, the hearing on hijab is underway before a constitution bench of the Supreme Court. Challenges again by Muslim women in the Supreme Court to the practice of nikah halal, polygamy, and certain provisions of the Muslim personal law are pending and slated for an October hearing this year. Could the struggles, ladies and gentlemen, of Muslim women and the time-consuming efforts of constitutional benches of the Supreme Court been avoided had a uniform civil code been in place as envisaged by the founding fathers of our Constitution and red flagged by Justice Chandrachud in 1985? How many more court battles do we have to witness on matters of personal law? Has the time finally arrived then, ladies and gentlemen, when it is imperative for the state to enact a uniform civil code as envisaged by Article 44? Today's speakers have been invited to share their invaluable insights on this issue of vital public importance. I wholeheartedly and warmly welcome them. Thank you.
Thank you very much to Jethmalani for your stirring words and for appropriately putting this whole ongoing debate we shall have in a fitting context. And if I may just respond by saying the following, that sometimes it appears to all of us, and I'm sure to Rhythm as well, that the impact on society of legislation is forgotten by the politicians themselves. And that is where perhaps the courts need to step in, and perhaps politicians need to rise to the occasion. You quoted Justice Chandrachud when he spoke about the missing aspect of official activity. Mr. Jethmalani, we are all doing this in the hope that there is this sense of frozen inertia about the Uniform Civil Code, which will end very soon. And that is, I would say, the backdrop of this entire series. So thank you very much, Mr. Jethmalani, for that. And ladies and gentlemen, it gives me great pride now to welcome on this platform the Honorable Vice President of India, Shri Jagdeep Dhankar ji, to kickstart this year's Ram Jethmalani Memorial Lecture Series. I'd like to say a few words about the Honorable Vice President along with my colleague Rhythm. Jagdeep Dhankar ji is a son of the soil. He's a Kisan Putra who has worked his way up in the courts and now holds the country's second highest constitutional position. He's a great speaker. I've had the opportunity to interview him in the past as well. But ladies and gentlemen, Mr. Jagdeep Dhankar has been integral to our public life in the Rajasthan courts, in the Supreme Court over many, many years. Rhythm.
Absolutely. And as we welcome our Vice President Arnab, Mr. Jethmalani, we remember he entered politics in 1980s. He was the MOS in Parliamentary Affairs in 1990. Also, he came to be known as the People's Governor before he became our Vice President. His story, Arnab, is one of grit, of merit, and someone standing for what they believe in.
Absolutely. Mr. Jagdeep Dhankar entered politics in the mid-1980s. He was elected as a Member of Parliament from Rajasthan's Jhunjhunu. He served as the MOS Parliamentary Affairs in 1990 and in important Lok Sabha committees. And he came to be known as a People's Governor, as Rhythm said, before he took oath as the Vice President. Mr. Jagdeep Dhankar epitomizes in many words, Rhythm, the India story. The story of grit, merit, and standing for what you believe. Rhythm.
Absolutely. So as this debate happens, we welcome our Vice President Arnab on the Uniform Civil Code that's going to take place in Parliament. He is the man most likely to be in the chair presiding over it all. Without further ado, we welcome Arnab, Mr. Vice President, to open up the third edition of the Ram Jethmalani Memorial Lecture Series.
My greetings to everyone. I am grateful to Arnab and Mahesh ji for those kind words. I am deeply humbled. Regarding the topic, very well chosen. Reflections have been by Mahesh ji. They are in depth and very thorough. I would speak about the man whom I have known for several decades. It started when we both became members of the parliament and on the same side. Being on the side of Jethmalani ji has always been a big relief, be it in court or otherwise. He has always been at the peak of his profession. In last several decades, more than 6 decades, he dominated the bar in criminal jurisprudence. I have been under his tutelage and always benefited. There have been occasions when I was on the other side. I remember that when great argument was there in the Supreme Court, the trial was unjustifiably delayed, and the prayer was being made that this should result in the person concerned getting relief. And in one argument, Jethmalani ji dealt with the entire issue. He said, can we have a situation in a society governed by law, in criminal jurisprudence, that there will be no trial? He was a genius. It will be very difficult for us to find another one in times to come. In every walk of life, even apart from the legal field, his presence was always impactful. He was inspiration, he generated motivation and generated a seed of aspiration in members of the bar. I see only 2 gentlemen making it out prominently in criminal jurisprudence, Frank Anthony and Jethmalani ji. Otherwise, in criminal jurisprudence, at the peak level, there has been total absence. All I can say at the moment, that the subject chosen is touching the heart of millions. It is an issue which is being debated at the moment. Framers of our Constitution, in their wisdom, rightly had in Part 4, Directive Principles of State Policy. One cannot understand how something which is there in Part 4 of the Constitution can be challenged, can be resisted. Mahesh was right when he read out the judgment that it has not received attention. If we examine the issue in global perspective, we will find in some countries right steps have been taken at the right time to have societal harmony, to have sublimity in our working. It is vital for all of us to deeply focus on directive principles of state policy. Article 14 debate indicates it in depth if we go through it. I therefore feel that this subject will generate and catalyze a situation where thinking minds will galvanize into action, and I have no doubt that galaxy of erudite speakers will give us enough to take home. This is a subject of great contemporaneous relevance. Everyone, irrespective of political spectrum, belief, must think whether we can further delay it. We are at the moment facing a situation that for lack of uniform civil code, several issues are arising and some of them are before the court. I therefore congratulate the organizers for being so forthright and far-sighted in choosing such a thought-provoking subject. I would conclude by indicating that Ram Jethmalani ji was a towering giant. both in the political spectrum, in the societal spectrum, and in legal field. I had the occasion when the tiger was in his 90s to face him in court, and that was a water dispute between two states, and he paid me ultimate tribute. When I told him, sir, you are rising in this court to make a plea that the matter be deferred, in his inimitable style, and I am greatly touched by his response, showing me love and affection, he said, sometimes deferment creates congenial atmosphere for resolution of a dispute where we must not have adversarial situation. Hats off to the man. He could speak out in that kind of mindset. He always wanted that litigation must not generate adversarial relationship once it comes to an end. I would say a word about Mahesh also. As Rajya Sabha chairman, Mahesh is a vital human resource, he himself being part of the house, and he is taking the baton from Ram Jethmalani ji very successfully. So best wishes to him. I look forward to the deliberations and inputs that will be afforded by the speakers with their rich talent, and I am sure that will help the society at large. I am grateful to the organizations for making this availability available to me. Thank you so much. Namaskar.
Thank you. Well, thank you. Thank you so much, Honorable Vice President Jagdeep Dhankarji. You summarized a few things very well. Of course, as you rightly mentioned, about Mr. Ram Jethmalani, his candor and his ability to take an opposite position without taking an adversarial stand necessarily. And I think what you also alluded to was his personal charm, Honorable Vice President, which allowed Mr. Ram Jethmalani sometimes to be on the other side of the bench, but without being considered to be an adversary. So I think that is remarkable. I also very much, we all appreciate what you said there about how something which is enshrined in our Constitution can be legally challenged. I think, Honorable Vice President, that when you will be on the chair, we all hope is going to be the time when the Uniform Civil Code is taken up as a piece of legislation, and we look forward to your inputs and your leadership in that as well. And I'm sure Mr. Mahesh Jethmalani greatly appreciates the warm words you've said for his father and, of course, for himself as well. So I'm very grateful, Honorable Vice President, for you for launching this conversation. Thank you, sir. Thank you. And ladies and gentlemen, let's move on with our program now. It gives me immense pleasure to our entire network to welcome the dynamic Solicitor General of India, the very erudite Mr. Tushar Mehta, as our next speaker. Mr. Mahesh Jethmalani, myself, Rhythm, and the entire network, for all of us, it is a great pleasure that Mr. Tushar Mehta is with us. Mr. Tushar Mehta is known to anyone really who keeps up with the news, ladies and gentlemen, because he has built a reputation for himself, truly, Rhythm, as a lawyer who can handle it all. Rhythm.
Absolutely. And as we welcome Mr. Tushar Mehta here, Solicitor General of India, we also say, Arnab, Mr. Jethmalani, he's been the person who's been at the forefront of every constitutional case, whether it's Article 370, whether there are center-state disputes, or whether it's corruption cases. He's the main man for the center when it comes to fighting disputes in the Supreme Court and the High Court. And I think specifically, Arnab, it comes to national security, national significance, and nation building, where he's most importantly used by the central government in the courts.
Absolutely. Whether it be the abrogation of Article 370, to the Ayodhya land dispute, to a gamut of corruption matters, or to matters of constitutional significance, as you said, on center-state disputes and much more, he's the lawyer who the center has been fielding. But on this occasion, what I must mention is that Mr. Tushar Mehta is someone who has witnessed the courtroom wit, battles, craft of Mr. Ram Jethmalani firsthand. We would like him to talk about this as well, whether by arguing alongside him or against him. Mr. Ram Jethmalani remains famous for his no-holds-barred style, and we know that Tushar Mehta in a way is no different. So to speak about the legal scholarship and personality of Mr. Jethmalani, his fierce representation of his clients and of him as a person, there could be no better voice than Mr. Tushar Mehta. Mr. Tushar Mehta, welcome to this lecture series, and over to you, sir.
Thank you, Arnab, thank you. First of all, I pay my regards to the Honorable Vice President of India. It's indeed a privilege to be a perennial member, a perennial participant in Sri Ram Jethmalani Memorial Lecture Series. I always come on this series not in my capacity as a Solicitor General, but always as a fan of Sri Ram Jethmalani. Ram, we used to lovingly call him. Arnab, my association with Ram had been very long and very intense. Mostly I always appeared with him, and in very few cases I appeared against him. But in either which ways, I ended up learning something new daily. Mostly people do a disservice to such a giant of a man by remembering him as a greatest criminal lawyer of the times. I don't agree with that. Ram Jethmalani was greatest lawyer of his times, be it criminal law, constitutional law, corporate law, or any subject which he handled. To confine his legal acumen to merely criminal law would be doing injustice to this giant. I am indeed grateful to his worthy son, Mahesh Jethmalani, who by his own right is an eminent lawyer, an eminent counsel, a person of eminence in Parliament also, and I am proud to say a very personal and a dear friend who treats me as a family. Friends, I would not be able to say anything much on the subject in my capacity as the Solicitor General of India. And as I said, my views are personal views, my views are as a student of law, and my views are as someone who is a fan of Sri Ram Jethmalani. First of all, let us make one thing clear, that Uniform Civil Code, a very right choice of subject chosen by my dear friend Mahesh for his father, is not a political slogan. It's not political slogan of a particular political party. People must know that this is the manifestation of desire of the framers of the Constitution, and it was the Constituent Assembly which put this particular provision as a desire in Article 44 of the Constitution of India. So first of all, let us not understand or evaluate this subject as a political slogan. Second, all of us know that India has always been a very reformative country. India is fast developing nation. We are competing with other developed nations also, and the world look upon us, look forward to us, and look at us with a country who will do wonders in times to come. I don't consider the question of Uniform Civil Code as a question of either any religious issue or any other angle. First of all, we can do injustice to the subject by linking this subject directly or indirectly with triple talaq issue. This is the mistake people from both the spectrum of the subject commit. Those who are in favor try to seek support from triple talaq issue. Those who are against try to find out some lacunas from the triple talaq issue. I therefore at the outset say that please do not treat this subject even remotely connected with triple talaq issue. For me, it's a question of equality in general and equality of women in particular. India has always treated men and women equally. That's our strength. That's how India is known not only within the country but outside the country. But except in cases of, say, political representation or employment, etc., there is less of the equality so far as women are concerned. And when I say this, it might at the outset sound to be a little startling statement. But on issues like, say, inheritance, right to property, right to a share in the property, several family matters, India could not treat women equally with men. As a matter of fact, even amongst the Hindus, the daughter got a co-partnership right very recently, relatively. So for me, this is a question of equality. Equality for women, one woman across the religion, governed by the same law across the religion. Second, equality in general. Friends, we know that all citizens are governed by several laws. For example, all penal laws are common for all citizens. There is no separate Indian penal code for Hindus, Muslims, Sikhs, Christians, Buddhists. No. The same procedure is adopted under the Criminal Procedure Code. We have uniform taxation laws across the religions. We have uniform laws pertaining to the properties across the religions. The question is, why can't we have uniform laws with regard to family issues and issues concerning human relations? This is where the question of equality comes. So when I talk of equality, I necessarily talk of equality between two women belonging to different religions, two men belonging to different religions, and one man and one woman belonging to the same religion. Can we not thrive to make everyone equal? Friends, India is always a reformative society. We have always been. We have always accepted change if it is a change for better. An average Indian is smart enough to know what is good, what is moral, what is ethical, what is in the best interest of the society, and what is in the best interest of the family. We have accepted in past Dowry Prohibition Act. We have accepted in past Child Marriage Restraint Act. There are several acts which across the religious borders are accepted by India as a society, as a nation. Can we not experiment making everyone equal with respect to every aspect of law? And that's the question which is going to be debated. Goa already has uniform civil code. Of course, there is a section of the society which says it needs some tweaking. Uttarakhand, I am told, is already experimenting on that. The question is, shall we or shall we not? That's the question on which all the learned speakers I am very eager to listen to would debate. But as a citizen of the country and as a student of law, I say the country is ready for this equality. It's of course a matter of legislative discretion, and therefore I can say nothing more on the subject. But if such a decision is taken, and as and when it is taken, if at all it is taken, I am sure the present government under the leadership of Honorable Prime Minister Modi ji has the political will and courage to take reformative steps if they are in larger national interest. Again, a caveat that these are my personal views. While debating also, I would request everyone not to mix up the triple talaq issue with the issue of uniform civil code, as according to me, this is merely an issue of equality. I am really thankful to my dear friend Mahesh and a very eminent journalist of the country and abroad, Arnab Goswami, and a very astute lawyer cum journalist, Rhythm Bhardwaj, for giving me this opportunity to share my personal views. Thank you very much, Arnab.
Well, thank you. Thank you very much, Honorable Solicitor General of India, Shri Tushar Mehta ji. And I think if I may just respond very briefly to what you said. First of all, I think all of us here understand the limitations, and you've put that caveat very strongly that as Solicitor General of India, these are your personal views. But while having said that, I must thank you as well on all our behalf for elevating the discussion to one on equality. Because very often, if this issue gets mired in politics, then it gets a different spin altogether. However, you have directly in a way linked it to Article 14, that it is the duty of the state that it shall not discriminate against any citizen, for or against any citizen on matters of religion, caste, sex, place of birth, and therefore you have linked it in a way what is enshrined in our directive principles to the fundamental right of equality that every citizen truly deserves. And I thank you for elevating this conversation to that. I thank you for your participation, for your warm words on Mr. Ram Jethmalani, and for helping us kick off this series. Thank you, Mr. Tushar Mehta. Thank you so much indeed. Thank you, sir. And ladies and gentlemen, now we are proceeding to, with Mr. Jethmalani's permission, we are proceeding to the operational part of the conversation, which we are really all looking forward to.
Arnav, take the event forward.
Thank you very much, sir. With your permission, sir. And it is our pleasure, privilege, to introduce the Honorable Governor of the state of Kerala, Mr. Arif Mohammed Khan. A few words about him. Mr. Arif Mohammed Khan is serving as the 22nd distinguished governor of Kerala. He has been a seasoned politician and has studied the law. He's a man who speaks his mind. I would call him a reformist and a man with a vision for the country. He's a visionary. Mr. Khan has walked out of the Rajiv Gandhi cabinet in 1986 protesting the then Prime Minister's stand in the Shah Bano case, which had paved the way for reform in Muslim personal law. He uninhibitedly defended the Supreme Court's judgment on the Shah Bano case in Parliament as well. And so when he speaks from conviction, which he has stood for in the past very times as well, and he's not put political office before his own conviction. Rhythm, would you like to add to that?
Absolutely. As we welcome Mr. Arif Mohammed Khan on the show, sir, we also remember he's donned numerous hats professionally, but what has shined through every time is that he is a reformist. Mr. Arif Mohammed Khan, for many years when India and people were silent on the issue of triple talaq, spoke up about it and said it should be punishable with 3 years in jail. He also welcomed the Karnataka High Court's judgment that upheld hijab is not an essential garment.
Absolutely. And Rhythm, he is on record saying, and I'm quoting Mr. Khan now, he said, it is obligatory on part of the state to take steps to create an environment conducive to the enactment of a uniform civil code as early as possible. These are his words. So today I'm sure that his lecture is awaited with bated breath. So without any further ado, let us all welcome and welcome warmly the Honorable Governor of Kerala, Mr. Arif Mohammed Khan. Over to you, sir.
Thank you very much, Ardabji, and your colleague, and my gratitude to Maheshji for the invitation. First, I would like to pay my tributes to late Shri Ram Jethmalani ji, who was, as rightly pointed out by Tusharji, not only a great legal mind, highly erudite, and his whether arguments in the courts or speeches in parliament, they were marked by wit and humor. And I am personally beneficiary, recipient of his love and affection. So I remember him fondly, and would like to compliment Maheshji for organizing this lecture in his name on a subject I am sure he must have been greatly interested in. Before I come to the topic, I would like to make reference to a noting on an official file by George Hamilton, who was Secretary of State for India soon after the British Crown had taken over the administration from East India Company after 1857. Now, while sitting in London, he is writing on this file which has gone from India. He says, "One hardly knows what to wish for India. Unity of ideas and actions would be very dangerous politically." These are very ringing words. He says, if we do anything which creates unity of ideas and actions among Indians, that would be very dangerous politically. Divergence of ideas and collision are administratively troublesome. Of the later, of the two, the later is least risky, though it throws anxiety and responsibility upon the officers on the spot where friction exists. So all whether they were constitutional measures, the policies, executive action, everything was decided in the light of this noting of the topmost officer, of the topmost British officer as far as India is concerned. So our problem is not really uniform civil code. Our problem is the colonial hangover we have not been able to get rid of. We still use, not just on the matter of uniform civil code, even otherwise, we continue to use the same language and idiom which we have inherited from the colonial powers. Do not forget that British India, the building block of India was community. The Britishers never recognized us as a nation. They said we are a conglomeration of communities, social groups. No one can have the right to speak on behalf of all Indians. In 1947, we became free. In 1949, we adopted our new constitution. According to the new constitution, it is not the communities which are the building block. It is the individual citizen who is the building block of Indian nation, of India as a state. Even if you look at Article 25, which is invoked frequently, when demands are made in the name of religion to allow things which essentially are of separatist nature, read the article carefully. The article does not give this right to the community. This is an individual's right. And I will give you an example. Say, for instance, in the Shah Bano case, when government decided to overturn the judgment of the Supreme Court, the Muslims of India, majority might have been of one opinion, but they all were not of one opinion. Now, when government accepted the interpretation of one group, then what practically it means? Practically, it means that you have those who did not differ with the interpretation of the Muslim Personal Law Board. You denied them the right to religion. Why? Because one group's opinion you imposed on everybody. Just now, Maheshji said that 1986 Shah Bano case, the remarks of Chief Justice Chandrachud, they failed to evoke any response from the politicians. And Arnabji, you also repeated the same thing. That is not right. It evoked response, but in the reverse direction. India at the time of independence or at the time of the making of the constitution had accepted that personal laws, family laws, we will accept the religious laws. We had accepted that. But in 1986, after the remarks of Justice Chandrachud, when we tried to deny protection of section, I think it is 425 or so, no, 125. 125. When we decided to deny protection to Muslim women under section 125 of CRPC, then we started marching in the opposite direction. Whereas the obligation, the constitutional obligation of the government was to create conducive atmosphere in the country so that uniform civil code can become possible. When the constitutional fathers, when they had inserted Article 44 in the Constitution, that represented advancement of thought, and the framers fondly hoped that with the advancement of education and the strengthening of national spirit, it would soon become a reality. But as I said, in fact, if you look at the proceedings of the Constituent Assembly, the framers of the Constitution were deeply aware that India had to suffer long spell of foreign domination or slavery because our society was divided from within. So they took two major steps. And the proceedings of the Constituent Assembly will make it clear to you that actually they contemplated three major steps, but they took two major steps. One was abolition of untouchability, and the other was abolition of separate electorate. Because through the instrumentality of caste which rested on untouchability, this society was deeply divided from within. And because of the separate electorate which was introduced by the Britishers, and that you should consider in the light of the noting of George Hamilton, why separate electorate was introduced. The separate electorate, if caste divided people on the social lines, separate electorate divided people on the religious lines. And the Constituent Assembly took these two major decisions to abolish both untouchability and the separate electorate. And regarding the third, they inserted a provision in the directive principles of policy, because you can it becomes fidelity to the ideal. We should be very faithful to the ideals. At the same time, one has to be sensitive to the actual. And they were aware that we have, not only that we have attained freedom after a long period of time, but our country has been partitioned. And our country partition was demanded on the basis that in united India, the religion of one community will be in danger, the culture will be in danger, everything which they have, that will be in danger. And that is the reason that you can, I would like to refer to an interview which was given by Pandit Jawaharlal Nehru to Taya Zinkin. Taya Zinkin was wife of an Indian, of an ICS officer who was British, who had stayed in India after India became free. But at the time when he was retiring, Taya Zinkin, who used to work for Guardian, she interviewed Pandit Jawaharlal Nehru. And during the course of this long interview, Taya Zinkin asked Panditji, who was a leading light of the freedom movement as well. She asked him, what you consider your life's greatest achievement? And Panditji unhesitatingly said, I was able to secure rights for my Hindu sisters, which were denied to them for centuries. And what was your major disappointment so far? And Panditji again said, he said, the thing which I did for my Hindu sisters, I could not do for my Muslim sisters. So we must, after all, now the freedom is 75 years old. The Uniform Civil Code is not to create uniformity in this country. This country has always cherished diversity. This country, right from the beginning of its civilizational journey, it has made the proclamation, Ekam Sat Vipra Bahuda Vadanti. This country has said, Bharateshu Istriya Pursho Nana Varna Pirkitite, Nana De Varchane Yukta Nana Karmani Kurvate. The people of India, they have different racial stock. Their customs and their rituals are different. Their modes of worship are different. We have always cherished diversity. We have always believed that all people should not be confined to one single interpretation of reality. Everyone, the truth is one, the reality is one, the Supreme Spirit is one, but it is described variously. And that is what Swami Vivekananda had also referred to in his speech in the Parliament of Religions. So this is not about, because if people apprehend, they fear that this will be used to create uniformity, then I ask the question that the Hindu law is applicable not only to the Hindus, it is applicable to the Sikhs, to the Buddhists, to the Jain. Has that law been able to create uniformity among all these communities? Not even among Hindus. The systems, the rituals, the customs are different in northern India. They are different in South India. The purpose is not to create some kind of imposed uniformity. No. The purpose of the Uniform Civil Code, as it was envisaged by the honorable members of the Constituent Assembly, was to create uniformity of justice, uniformity of rights and obligations which arise from certain facts like marriage. It is the uniformity of justice, not uniformity, and nobody is interested. Sometimes point is made that this is some hidden agenda, particularly the name of the RSS is mentioned. Here I have with me an interview which was given by RSS chief, and mind you, I'm quoting it. I do not totally agree with this interview, but on the question of uniformity, I'm referring to this interview. This interview he gave to organizer on 26 August 1972. And the question was asked by Mr. Malkani, who was later Rajya Sabha member, Lieutenant Governor of Puducherry. He asked this question: you don't think that a uniform civil code is necessary for promoting the feeling of nationalism? And I don't. This might surprise you or many others. I see. Then Guru Golwalkar ji said that Europe is a young continent. Their civilization is new. Our civilization is time-tested civilization. We diversity. We cherish diversity. So this fear should be, they should get rid of this fear that there is any design behind this constitutional proposal. Uniform civil code, any if it really is going to create problems as far as the practice of religion is concerned, then my question is that the Muslims who live in Europe, Muslims who live in United States of America, even Muslims who live in a Muslim country like Turkey, have they become less Muslim? This Muslim personal law, which people try to preserve, this is not applicable even in India, in all these states. Goa has a uniform civil code. Kashmir, this law is not applied. Are these people less Muslims? And secondly, because the question of religion is brought into this issue, therefore I would like to quote something from the religious scripture. Constitution of a country in Arabic is described as misaq, covenant, some great understanding which has been reached. Now the question is that who are the members of the Constituent Assembly? I don't want to mention other names, but Maulana Abul Kalam Azad was also there. There were many other Muslims there. Now, and I'm really surprised when I see anybody who has taken oath of the Constitution. And it is essential to take oath of the Constitution if you become member of any elected body, even as a citizen. When you participate in certain activities, you have to take oath of the Constitution. So how anybody who has taken oath of the Constitution can, if they argue that the time is not yet right, let us wait for some more time, I can understand. I may differ with that viewpoint. But when they outrightly oppose uniform civil code, I am surprised that are they aware the oath which they have taken to uphold the constitution of the country, and they do it in the name of Islam. And Islam views very negatively those who break the promise which they have made. And one of the verses of the Quran says, Allazina yanquduna ahdallahi min ba'di misaqihi wa yaqta'una ma amara Allahu bihi an yusala. And those who break the covenant after it is ratified. Constitution is misa. And then further, again, because opposition is uniform civil code is opposed in the name of religion, therefore I am relying on the scripture. Otherwise, there was no need for me. Further, it is said that, I have not found in any book, if anybody, any scholar, or any person who claims as representative or is speaking on taking into consideration the religious susceptibilities, if they can enlighten us that is there anything written anywhere which says that the criminal law of Islam is less important and personal law of Islam is more important, mercantile law is less important, only the family law, where where the man gets more rights. Otherwise, in the criminal law, there is no difference. So our preference is only for that part of the law which gives privacy to men, which confers more rights on men. In fact, Quran condemns this mindset and says, "Afatu'minuna bibadil kitabi wa takfuruna bibad." Then it is only a part of the book that you believe in, and do you reject it as? But what is the reward of those among you who behave like this, but disgrace is this life? And we are seeing it everywhere, because this distinction between the criminal law, mercantile law, personal law, this in itself making any distinction between different branches of law itself is unacceptable. And then I would like to, I think I have taken enough time. I would like to conclude. I would like to ask this question, whether during the period of Sultanate, whether during the period of when the Mughals were ruling, the personal law which we have today, that was not there. The Muslims of India till 1937, except the performance of the customs and rituals, otherwise in matter of succession, in matter of adoption, they were following the customary laws of the communities to which they belong. It was only in 1937 when the British, they were pursuing the policy which I referred to in the beginning, to create the consciousness that we are different, which ultimately culminated in the demand for partition of the country. Till 1937, Muslims belonging to different communities, Gujarati Muslims, were following their own customary laws. People in Kerala were following their own customary laws. It was again the handiwork of the British to create divisions in the society. Therefore, I hold the view that uniform civil code, as this is part of the directive principles of the Constitution, therefore it is our obligation, it is our duty to create conducive atmosphere in the country, remove the misunderstandings, go to the people, educate them, tell them that this is not about creating social uniformity or the civil uniformity. This is about uniformity of justice. This is about uniformity of obligations and duties which arise from certain facts like merit. And I feel that definitely time has come when we should we should go forward and take positive steps in the direction of fulfillment of this constitutional promise. Thank you very much. Jai Hind.
Thank you very much. Thank you, Honorable Governor Shri Arif Mohammad Khan ji, and for your very, very erudite and extremely well-researched address on this occasion. And if I may say so, your particular reference to what was said by Lord Hamilton, who you put in an appropriate context, your argument that it was perhaps a well-thought-out attempt by the British to create a legal defense, some kind of a legal defense to keep our society divided. These are words which will go a very long way. You also alluded very strongly to the fact, I totally agree with you, that the time has come for us to take up the mantle which was left upon us by the Constituent Assembly of this country, which removed aspects such as the separate electorate, but left it to the future rulers of this country to take the next step. And that is why they left the reference in the Uniform Civil Code in Article 44 of the Constitution. The very fact that for over 7 decades we have left it untouched is something we must debate on today. Shri Arif Mohammad Khan, also very importantly, you would know that the time has come and everyone's thinking about it. The Supreme Court is now thinking about whether, and the bench comprising Chief Justice of India, UU Lalit, and Justice Ravindra Bhatt just a few days back asked the centre to make it stand clear, within 3 weeks in fact, on the feasibility of implementing such a code. So your words, this conversation on this occasion is going to go a long way in stirring up the much necessary conversation on the subject. For your most erudite words today, we all are very grateful, and I thank you all very much. Thank you very much. And Mr. Sharif Muhammad Khan. And now I'd like to go across to welcome the next lecture on our theme, ladies and gentlemen, which is, I remind you, has the need for a uniform civil code become an imperative today? Our next lecture is by Justice Kurian Joseph. With a legal career spanning over 4 decades, he has literally seen it all. Former judge of the Supreme Court of India, previously served as Chief Justice of Himachal Pradesh High Court, and as a judge in the Kerala High Court. He has authored over 1,000 judgments and orders during his tenure as a Supreme Court judge, which is a record-breaking feat. And perhaps the most significant judgment to mention on this occasion is that, Rhythm, on triple talaq. Rhythm.
Yes. In fact, I can see Justice Kurian Joseph's trademark smile on his face, which we were so used to seeing in the courts. Sir, as we welcome you, you were a part of the majority that deemed the practice unconstitutional in the landmark Shaira Bano versus Union of India case. We as women in the Supreme Court at that time rejoiced at your words when you said triple talaq is against the tenets of the Holy Quran and violates the Shariat.
Absolutely. So I don't think we must take more time. We are all very keenly looking forward to your address. Justice Kurian Joseph, your vast legal knowledge guarantees that this lecture in the memory of the one and only Ram Jethmalani is all going to be very illuminating for the legal fraternity and those outside it. So on behalf of Sri Mahesh Jethmalani, who is with me here today, all our colleagues, it is my pleasure to welcome you, sir, to the Ram Jethmalani Memorial Lecture Series. Over to you, Justice Kurian Joseph.
Thank you, Mr. Arnab, and thank you, Ritu, for the kind words spoken of me. I still remember the day when this triple talaq judgment was pronounced. After the minority judgment was read out, people were running around and saying that it has been upheld. But the majority judgment, in fact, I ordered the leading judgment. When that was pronounced, Chief Justice said, wait, we have to see what others also have to say. Well, it's an absolute pleasure on my side to share a stage with our Honorable Vice President, His Excellency Mr. Jagdeep Dhankar, and also the Honorable Governor of Kerala. And let me pay my tribute to Mr. Jethmalani first. Let me share something very personal. His last argument was in my court. When he finished his arguments, he said, today I'm laying down my professional career as a lawyer. This is my last argument in my court. So I always cherish that day. The bench headed by me, he said, this is my last argument in the court. So I'm not more going to appear in any court. So that is something very, very exclusively personal to me. I always cherish those words. And I loved him. And that is one reason, apart from, of course, my personal relationship with Mr. Mahesh, that brought me here to be part of this lecture series. I always held Mr. Jethmalani in very high esteem. He was one lawyer who was approachable to anybody. And he was one lawyer who had never refused a brief of anybody. And who is one lawyer in India who has argued on all aspects of non-legal jurisprudence as of now. These 3-4 points I would like to remember about him before I start my lecture. Well, the topic today is, has the need for uniform civil code become imperative for India today? My first question is it the imperative need for India today? Is that what is the imperative need for India today? Is that what is standing against the growth of India or growth of nationalism or national integration? These are my personal observations. I'm not representing anybody or any community, but my personal observations on looking at the scenario in India. I feel that there are more important aspects which needs country's attention today, and even the Supreme Court of India also, because this Article 44 on Uniform Civil Code comes under the directive principles. Directive principles are meant for the state to make laws. The Constitution says it's not for a court to take the lead. The Constitution clearly says it's under the duty of the state to apply these principles in making laws. So therefore, this is something to gain the attention of different platforms. This is my personal observation on what's happening. To me, in the directive principles, because we have constituted ourselves into a sovereign socialist democratic secular Republic of India, are we in a position still, after 75 years, to say that sovereign, yes, republic, yes, but as far as democratic, socialist, and secular republic is concerned, have we been able to, as the Honorable Governor pointed out, been able to enjoy this justice, which is social, economic, and political, liberty of thought expression, faith, belief, and worship, equality of status and opportunity, and promotion of fraternity, assuring the dignity of individual? Are these constitutional values are comfortably available for experiencing and enjoying for the ordinary citizen of this country? Is it the lack of a uniform civil code that stands for an ordinary citizen of this country, that the baker, butcher, that ordinary man of this country to experience that I am an important citizen of this country, I live in a democratic country where I have a space and I have a voice, and my views are respected, even if it is counter-majoritarian, even if it is my own views. Well, in directive principles also, have we made serious attempts on many of these aspects? Because this is under Article 44, Uniform Civil Code. The states shall endeavor to make us uniform. But prior to that, there are several things which a state should engage its attention. For example, Article 38. The state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, political shall inform all the institutions of national life. Is it available? Have we been able to attain that? The state shall in particular strive to minimize the inequalities of income and endeavor to eliminate inequalities in states, facilities, and opportunities, not only amongst individuals, but also amongst groups of people residing in different areas or engaged in different occasions. Have been able to attain that? The state shall, in particular, direct the policy towards securing that citizens, men and women, equally have the right to an adequate means to livelihood. Ownership and control of a material resource of the community are so distributed as best to subserve common good. Operation of economic system does not result in the concentration of wealth and means of production to the common detriment. Is that the concentration of wealth issue being addressed by this country on the real principles of socialism, on equitable distribution of wealth, equal pay for equal work, health and strength of workers, men and women, and the tender age of children are not abused, and that citizens are not forced by economic necessity to enter avocations unsuited to their age or strength. Have we been able to address this? Let's look at the reality, what's happening about the children. We had recently a conference where we were thinking about the fate of children here who have been abused and who still see. If we just look around Delhi, I've been part of an organization where we have been trying to give an informal education to the children on the street. A boy of 17, when we taught him to write in Hindi his name, he was so excited. And I could see going around the city probably by distributing food, etc. in the corona times, even now also sometimes. There are thousands of children on the streets. Forget about those working in factories or hotels or etc. So have you been able to address this issue? That children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. Then comes equal justice, right to work, right to education, just and humane conditions, living wage for workers, and then comes independence of judiciary. That also is one of the articles which govern our govern our directive, which is in the directive principles of state policy. So, is it the hour, or is it the time when we have to address several other concerns of people, of their insecurity, of their dignity to live as free citizens of a country? I don't mean any community. Forget about the feeling or apprehension of the people that the Uniform Civil Code will definitely affect the religious freedom. Yes, it is one of the concerns because Article 25 provides for religious freedom also. Even among Hindus, I was just looking at the Hindu Marriage Act. I've been able to make it uniform among the several sections of Hindus. So to me, I would say, let us reform our own personal laws so as to make it a law which is in conformity with the constitutional dreams and which will serve the constitutional values. Let us address that issue first. Reform our personal laws, in all personal laws, whether it is for majority community or minority communities, and make it constitutional by appropriate reforms or appropriate amendments. Thereafter, let us think about this subject. Then it will be easier for India. And particularly given the times, I would say, there are several other major concerns for the country to address now. And let's not think about a situation where the uniformity is what is required for unity. Particularly for India, it is not the uniformity what is required for unity. What is required for unity is actually the feeling of security that I am a free citizen of this country, irrespective of caste, color, creed, religion, language, gender, or place of birth. I have my space and I have my voice. No religion, no law ever should interfere into my dignity as a human being, as a citizen of this country. So let us infuse this confidence in the minds of everybody, whether majority or minority, this particular party, that particular party. No, every citizen of this country has equal access to justice and is in a position to enjoy the freedom that democracy gives, that space that democracy assures, that voice that is the core of democracy. Without which, if you think of this sort of discussions, I do not think that we'll be able to make India a great India. If you want to make India a great India, let's have an India where its citizens are in a position to enjoy this liberty of thought expression, faith, belief, and worship, which is to whom justice, social, economic, and political are available. Dignity of the person, irrespective of gender, is protected. This main concern is about the dignity to the women. Yes, it is very important. But let us reform our personal laws, whereby, just as it was said about the triple talaq, where in our own personal laws, this is not actually addressed, if not respected. So let us address those aspects, those issues which are against our constitutional dreams or constitutional values of constitutional morality, I must say, of dignity, equality, and liberty of women by reforming the personal laws. And thereafter, let us think of this situation. So to me, I would say this is not the time for such a discussion. And this is not the imperative need for the country as of now. Thank you. Jai Hind.
Well, thank you. Thank you, Justice Kurian Joseph, for your very clear words on the subject. And just in summary, responding to just a couple of the points I want to summarize, you have focused greatly on the issue of timing at the introductory part and towards the end of your lecture as well. And you've essentially said that unless other aspects of Indian society, other areas of inequality are dealt with, this is not the most imperative time. So you've spent a substantial time on the word imperative, and I think that will spark a new debate on. You've also made the point on national integration, whether it would really help the country. Well, in past cases before the Supreme Court, I remember, Justice Joseph, the John Valamotam case, 2003, the court had said that the Common Civil Code will, quote unquote, help the cause of national integration by removing all contradictions based on ideologies. But that matter also should be up for debate. And finally, you spoke about women, and you rightly said that present laws can also be reformed. Present laws can be improved. And to a large extent, I would agree with you, and many people would agree with you, but others would also say that maybe a UCC will help women fighting for legal succession, or seeking divorce, or the equal right to worship, or contract marriages, or custody of children. But these are issues of perspective. And I think your words, you're not completely opposing the idea of a uniform civil code. You're really questioning the timing, whether this is the time to look at it with the kind of keen lens that some people would like to. Well, I thank you very much. This has been most refreshing, and it's been a pleasure having you on this platform and on Republic. Thank you very much. Thank you.
Thank you.
Thank you, Justice Kurian Joseph. Thank you. Thank you. And up next, as this conversation becomes more and more interesting, and we are getting different perspectives every single minute. And I must say, Mr. Jethmalani, that being a natural debater, you and I and Rhythm, we are all holding ourselves back from putting our own 2 bits into the conversation, because it's so strong and so learned.
Just a word here.
Yes,
I
yes,
mean,
please.
that's the whole purpose of the Ram Jethmalani Memorial Lecture.
Yes.
We want diverse points of view.
Yes.
And the Justice Kurian Joseph was talking about freedom of expression. That's what we must secure. That's the priority in this country.
Yes.
More than the uniform civil code. On that, of course, we'll talk at the end of the show. But this is a platform for diverse views.
Yes.
And it is from diversity that a solution will actually finally emerge.
Inevitably. It shall. And up next now is a lecture from Ms. Madhavi Goradia Diwan. I'd like to say a few words in introduction. She's a senior advocate and an additional Solicitor General in the Supreme Court. And she is the youngest woman to have been appointed to this post. From commencing her career in the High Court of Bombay with a largely commercial law practice, very successful, to practicing in the Supreme Court on a range of subjects, including constitutional law, media law, and environmental law, she has an astute hold and understanding of the law from different perspectives. Over to you, Rhythm.
Absolutely. And Arnav, like you said, Madhavi Diwan represented the government of India, various landmark cases. This includes, of course, the notable Triple Talaq case. It was the first time in independent India that we actually saw the government taking a stand that was drafted by her. She was entrusted with the task of framing the government of India's response to the petition in the Triple Talaq case. And in fact, it was a path-breaking affidavit that had been drafted by her, where I remember the words were, Mr. Jethmalani also, she said, secularism being a hallmark of Indian democracy, no part of its citizenry ought to be denied access to fundamental rights.
Absolutely. But, you know, in that context, when you mentioned what she had said in the affidavit in the Triple Talaq case, you would also note that the Honorable Solicitor General, beginning the conversation, kept harping on the point that the discussion on the Uniform Civil Code should not necessarily be linked to the ongoing discussion on Triple Talaq. He was putting this word of caution, and I'm sure at this very point of time the government is firming up its views on the response in the Supreme Court to the issue of clarity on the Uniform Civil Codes, which she will be a part of as well. Well, that case culminated in the historic abolition of the practice and is often touted to be the gateway, as some say still, to bring in the Uniform Civil Code. And I'm sure today that Ms. Dewan will bring in personal insight from all the cases she has fought and legal scholarship to her lecture. I welcome Ms. Dewan to deliver her lecture right now. Over to you. Over to you, Ms. Dewan.
Thank you very much, and thank you first of all for the privilege of this invite on this very momentous subject of the Uniform Civil Code. And I might add here, having looked at the very illustrious names on this panel, I'm privileged to be here also, because without my presence this might have ended up as a manel. So well, I must also say that the views that I express today are not official. They are my own views based on my understanding and experience as a lawyer, as a law writer, as a law officer in recent years, but most importantly, as a citizen of this very vibrant and diverse country. The UCC, the Uniform Civil Code, means a myriad different things to different people, and in fact it evokes such strong reactions. Oftentimes it's a red rag for some who believe that this is simply a license to obliterate diversity in India. Now, I think I'd like to say first of all that I do not subscribe to those views at all, and it's important to at the very outset emphasize that there is a fundamental difference between the erasure of diversity on the one hand and the erasure of disparity. What I think the UCC seeks to do is to erase disparity. Disparity in a manner which will be consistent with our constitutional commitments, and the erasure of that disparity which it seeks to do would be both inter-community and intra-community. So that is my understanding of what the Uniform Civil Code stands for in a nutshell. Now, we all know that the UCC appears in Article 44 of the Constitution, that is part of the directive principles of state policy, and Part 4 is not enforceable in the manner that fundamental rights are. We know this. However, when we read Article 44 alongside the freedom of religion, which is in Part 3, and in particular Article 25, what becomes clear is that this is part of a very well thought out, harmonious code which has been put into place by our constitution makers. And I see complete harmony, and I'll explain why, between the freedom of religion as guaranteed, particularly under Article 25 and Article 44. Of course, Article 44 being part of the directive principles, it is not enforceable, it's only a constitutional aspiration, but nonetheless, there is a clear, it can be beautifully tied up with the freedom of religion. Now, when we look at the at Article 25, which is the freedom of religion, the right to profess, practice, propagate religion, it's important to note that there are some caveats, some qualifications to this right which appear in Article 25 itself. Very loudly and clearly it has been put there by our constitution framers. And one of those caveats in particular is that the state shall not be prevented from making any law providing for social welfare and reform. So inbuilt in Article 25 itself is a recognition and acknowledgement by our constitution makers that religious practices may require reform, we may require social welfare measures. So that is an open acknowledgement right there at the very outset. Now, when this is inbuilt, this acknowledgement and this requirement of social reform is inbuilt into the words of Article 25 itself, it means this, that there is a commensurate obligation while we enjoy our freedom of religion, and a commensurate obligation to embrace reform when it comes. There is absolutely no right to intransigence under our constitution. That is very loud and clear in Article 25 itself. There is nothing which is set in stone, so to say. There is no right to resist reform. That is clear from Article 25 itself. Now, therefore, it is not an unqualified right. So the question may be that, all right, there should be reform, but where does the UCC come into this? Now, when we do recognize that there is reform which is required, when that reform does come in, when you bring in something new, when the state is bringing in something new for the purposes of that reform, it is very important for the state, and a secular state in particular, to treat all its citizens and to treat all communities with an even hand. There can be no discrimination between communities. And therefore, when that reform is to be brought in, there has to be equality and even-handedness, and no discrimination, which can only be achieved essentially through a uniform civil code. Now, so therefore, the idea of a uniform civil code then is to treat all communities on an even keel. And as Mr. Arif Muhammad Khan said, as I heard him say, that the idea is to ensure equality of justice to all. Now, when we the people gave ourselves this constitution, what is it that we really sought to do? One of the very celebrated scholars on the Constitution of India, that is Granville Austin, he described the Constitution as a social revolutionary statement. And it was nothing short of a revolution, because the Constitution was meant to be a charter for social disruption. Disruption in the sense that we were trying to break out of a long entrenched status quo where we had deep divisions in society on account of caste, the scourges of caste, of intercommunity violence and all of that. And also, of course, gender inequality, gross inequity towards women. So the idea was to shake ourselves out of that and to establish a modern democratic society which would be based on certain fundamental values. Now, what were those modern fundamental values? Those values were equality, of course. There would be equal status for women in particular, gender justice, dignity for women in particular, and of course everybody else. But these were the founding values, and these were modern values that did not belong or were not taken from any particular community. So these were in that sense foundational values which we decided, we as the people of India, we decided to commit ourselves to this. And when we decided to commit ourselves to these values, it really meant that we had to be ready to make some sacrifices, every community across the board. And mind you, when Article 25 came about and the Constitution was brought into force, Hindu society too was in dire need of reform. So this was a pact between us, that is we the people, to commit ourselves to some reform in which we would have to give and take a little bit. That is very that is ingrained in the Constitution itself. And another very important value which we also committed ourselves to, and which is emblazoned in the preamble to the Constitution, is fraternity. Fraternity, a value which is not spoken about enough, but it is walking together in tandem as communities, as different communities, sub-communities. It's very, very important to walk in tandem, to fraternize, and to ensure that nobody is left behind. And social economic imbalance takes place between communities because we are not walking together and we are not perhaps embracing reform in a manner which gives justice to all members of the community. Now, it is these values, and I would describe, these are unifying values, these modern values which I mentioned, which did not come from any particular community. These were the unifying values which form the core of the Uniform Civil Code, the idea of the Uniform Civil Code. So rather than just play on the word uniform, I would look at it as a unifying civil code. It is that common cord, that common sutra, in a sense, that binds us together as we, the people who committed ourselves to this social revolution. Now, coming back for a moment to the freedom of religion under Article 25 in particular, I would say that apart from the other qualifications, which is that the freedom of religion was subject to the other provisions under Part 3, that is other fundamental rights, that apart, it was also qualified by another important caveat, and that was that nothing shall prevent the state from making any law which in order to regulate or restrict practices which are political, economic or other secular practices which may be associated with religious practices. Now, what are those secular practices? These are marriage, divorce, adoption, succession. Now, these are practices which the Supreme Court, these are matters which the Supreme Court has described as secular practices. Why secular? Because marriage, divorce, adoption, inheritance are matters which confer on us as individuals, as citizens. They confer a certain status and an identity which endures beyond our interactions in our own community. So it goes on to our secular interactions as well, and therefore these are treated a little differently. Now, these are areas, inheritance, marriage, divorce, these are areas where women traditionally got a particularly raw deal. And that is what the Uniform Civil Code would seek to redress. This is something where, and therefore I would actually say that the Uniform Civil Code has a feminist agenda. It's primarily feminist because in institutions, in matters of marriage, divorce, inheritance, it is women who have really had an unfair deal. Now, just to give you a few examples, when it comes to, say, divorce, which was not, there are certain communities, Hindus, Christians also, marriage was regarded as a sacrament, and therefore divorce was, in a sense, something which came in later as a recognition of certain social realities. Now, when, say, a Hindu couple wants a divorce, they go under their law. Parsis, interestingly, we are still covered by, they're still covered by what is known as Parsi matrimonial jurisdiction, which requires a jury trial. So members of that community have to sit in a jury to be able to decide the case, and quite recently the Bombay High Court described this as a very, a tedious and very time-consuming process which required some kind of streamlining. Now, oftentimes the process itself can be a punishment. Even among Hindus, it's not that easy. For Parsis, there is this jury trial. Now, if you compare this, for example, to a Muslim divorce, if it is initiated by the man, then, of course, even though today instantaneous triple talaq has been outlawed, but nonetheless, even the existing forms of talaq available to a man would take about 3 months, and they are essentially unilateral. Now, it's much smoother for a man, so, he may say that, look, why would you want to put me through that process? I don't want to go through any long drawn process and, present myself in court. So it's a very swift process for him. However, that very process, the swiftness of that process, the unilateral aspect of that process may be a punishment for the woman. That process may be a punishment for her. So therefore, we have these disparities perhaps which need some kind of redress. Now, even when we talk of, say, bigamy or polygamy, and of course I want to emphasize that, look, this is not confined to the Muslim community alone. It's much beyond that. We know that. But these are things which determine the status of a woman. So, for instance, it's all well to say that, look, how many cases of bigamy or polygamy do you see in X community or Y community? They're not very much in number. But that's not the point. The point is that when that law applies, to a particular community. It means that the woman is inherently unequal because she knows at the back of her mind the prospect of her being divorced very swiftly and unilaterally, or the prospect of her husband getting home another wife. It's a real prospect, and therefore that determines her status, her conduct in her home, her aspirations outside the home, and therefore that is really determinative of her social status. Now, these are things which the Uniform Civil Code would try to redress, because all women, no matter what community you belong to, are entitled to a full enjoyment of what the Constitution, a modern Constitution, offers to us. And therefore, there can be no disparity in your social, your basic human dignity, your basic social status. It is what we would call a certain grand norm of values, a certain baseline of values, a commitment that no matter what, no member of any community should be treated in a manner which goes below that baseline. So we, the people of India, committed ourselves to that grand norm of values, that lowest common denominator at the very least, if I may put it that way. Now, I'd say that, we've postponed this much too long. This has been many years late, but it is still never too late. And all this whataboutery about other, there's a lot of progress which has been made on other directive principles as well. It's not as if progress hasn't been made, but there are other communities which require, all communities, perhaps including the Hindu community, requires reform, perhaps in many areas. So therefore, that is not an answer. And I would say that had we had a uniform civil code decades ago, perhaps a stitch in time would have saved 9. Because but for a uniform civil code, if we had one, perhaps Shah Bano may never have needed to go to court. Shaira Bano in 2017 may not have needed to go to court at all, and we would not have perhaps had to flood the court with so many dozens and dozens of cases, which in many ways, because it deals with so many intricacies of personal law, it may be ill-equipped to handle. So therefore, there are cases, other cases, not just about marriage and divorce, but adoption, succession, all of that. And therefore, I would say that we need a uniform civil code. And what tends to happen is, if all communities say our religion, our faith is a way of life, and it requires no intrusion at all. Hindus may say it's a way of life. Muslims may say ours is a self-contained code. Somebody else may say something else. But if we were to do that, and resist this kind of reform, or resist the embracing a common grand norm of values, we would become nations within a nation, which is a very dangerous thing. And I would say that unless we embrace those unifying values, what tends to happen, and I think we have lost out in the last 7 decades on that front, because this only tends to exacerbate the social imbalance in society. The socio-economic progress of some communities tends to get left behind, and that only creates more fissures and unrest in society. So I would say better late than never. And with that, of course, I will acknowledge that this task, the project of a uniform civil code, requires a great deal of skill. It requires a great deal of sensitivity, undoubtedly, but it is better late than never. Thank you. Thank you very much.
Thank you. I mean, that was absolutely remarkable, Ms. Dewan, because you brought in a completely different dimension to the way in which we've been having this conversation so far. And what you've done, if I may just respond while in summary to some of your points, is that you have provided the sociological reasons behind a very sharp legal argument. When you were speaking about the caveats to Article 25, and you said there's a possibility of reform, I would really think that it is a responsibility to reform. And you also spoke about the homogeneity and changes in society. As you know, Ms. Dewan, recently, and as Mahesh, we've all been observing, when the courts have been talking of the matter, they've been talking about the nature of Indian society itself. As a society, are we becoming more homogeneous, or more differentiated. And any society should really aim and towards, as we become a superpower, to be more homogeneous. And I think this is what the Delhi High Court said when it said that in modern Indian society, which has gradually become homogeneous, the traditional barriers of religion, community and caste are dissipating. And if that is the vision which we have, then the Uniform Civil Code is a step in that direction. I really appreciated what you said there about Parsi women and the recent observations of the Bombay High Court there. And it fits in very well, because it does not matter how many Muslim women would be worried about their husbands bringing in another wife, or how many cases of bigamy or polygamy do exist. The very fact that it exists, how many Parsi women would go through a cumbersome divorce is not the question about as important as is the divorce procedure for Parsis exasperatingly cumbersome, and why should a Parsi woman who wants to have a fresh start in her life be denied what other women would access through their legal systems. So these are remarkable, Ms. Dewan, because these are very simple facts which you've said, but they are also the most piercing. And I think this has been a wonderful lecture from your part. We're all very grateful. We were all listening very keenly. I thank you very much. Anything you'd like to add, Mr. Jethmalani?
No, I think one statement of Madhvi's stands out for me, and it resonates with me a lot, and it's what I said in my opening remarks, that the Uniform Civil Code is really a question of gender justice. And Madhvi put it so well by saying UCC is a feminist agenda. I couldn't agree more.
Absolutely. We've seen this in cases like the Sabrimala case. The petition was filed by Muslim women for permitting Muslim women to enter mosques. So the society is changing. I think that's also a fundamental point. Well, you said this in a personal capacity. We look forward to what the government says in court. Thank you, Ms. Dewan. Thank you very much. Thank you. It's been a pleasure.
Thank you. Thank you very much. Thank you.
Wow, these are great conversations we are having. And I think such detailed conversations on a subject like this haven't happened before. If Ram had been around, he'd be really happy.
Oh yeah, subject after his own heart. Yes,
it's
absolutely.
A subject after Ram's own heart. And now, ladies and gentlemen, our next speaker, and he knows this. I don't see eye to eye with him, and he knows that. But he's an outspoken man, and we disagreed almost on everything, unfortunately. But he has his own stand on what he believes in, and we have our own stand on what we believe in. But it is a privilege yet to introduce Mr. Asaduddin Owaisi today. He's a brilliant mind, and he's a 4-time member of Parliament representing the Hyderabad constituency. He's the president of the All India Majlis-e-Ittihadul Muslimin. And as we all know, he's a barrister rhythm from Lincoln's in London, and a man to watch out for politically as well. Would you like to add something?
Absolutely. Arnab, like you said, politically, his party is expanding, having made an entry in Bihar, Maharashtra, Uttar Pradesh, very soon a debut in Rajasthan. Legislatively, he's been a staunch critic of the Uniform Civil Code, but Mr. Owaisi's advocates for the abolition of the Hajj subsidy given to the Indian Muslims and utilizing the money for the education of Muslim women. However, he also advocates for allowing hijabs in school.
So he has a diverse range of views, and whatever his views are in Parliament and in courts, wherever he can, in public forums, he speaks about it passionately.
One last word on my friend Asaduddin. Yes. I have to tell you that whether you agree with him or you disagree with him, he is a man of conviction. And I, more than anything else, I respect him for being a man of his conviction.
Absolutely. And I'm sure he'll add diversity to this conversation. I remember when the law against triple talaq was being debated in Parliament, he argued against its criminalization. He never minced his words on the UCC, and he has said in the past, he said the Uniform Civil Code is not required in this country. So it will undoubtedly be riveting after hearing the learned Additional Solicitor General last, to hear his views on the question, has the need for a Uniform Civil Code become an imperative today? Over to you, Mr. Asaduddin Owaisi. Over to you.
Thank you so much. Thank you, Mr. Jethmalani, for inviting me to the 17th Ram Jethmalani Memorial Lecture. And since this event is in the memory of Ram Jethmalani, I will honor it by speaking my mind without ifs and buts. Let me start by quoting what the late Ram Jethmalani had said. To put it into context, yes, I oppose Uniform Civil Code, and anyone who opposes the Uniform Civil Code becomes very unpopular for the BJP people and for all the people who hold the RSS ideology. So let me start by the quote of Ram Jethmalani when he said, "If defending an unpopular cause results unpopularity, so be it." I had many disagreements with the late Mr. Jethmalani, but I did respect him for his integrity. I remember that he expressed regret on endorsing Mr. Modi after he discovered that Modi government was not sincere about its promises on black money. In 2004, Mr. Ram Jethmalani had apologized for having supported Pota and regretted that it was used to target innocent people. It takes courage to stand by what you believe is right and admit when one is wrong. Uniform Civil Code is not imperative. I will set out three interconnected grounds for my stand. Firstly, the historical background of UCC in the Constituent Assembly. Secondly, pluralism and fundamental rights. Thirdly, difference between law in books and the law in action. Now, mandatory versus voluntary. Baba Sahib Ambedkar did not see Uniform Civil Code as mandatory. He believed it was voluntary. He wanted a non-religious secular law that is accessible to anyone who does not adhere to any faith. Today, this code already exists. The Juvenile Justice Act, Special Marriage Act, Indian Succession Act already exist. Anyone who does not want to be governed by religious personal laws can be voluntarily governed by these laws. Now, the Prime Minister Modi's own law commission noted in 2018 that UCC is neither necessary nor desirable. The commission was headed by former Supreme Court Justice B.S. Chauhan. He made this observation after public consultation and thorough analysis of existing legislative framework. Now, pluralism is the basis of this country. Uniformity does not mean sameness, and equality does not necessarily entail uniformity. Religion is not merely about worship or rituals. For most Indians, religion governs the relationship, their understanding of family, of property, of marriage, child rearing, etc. It creates what one may call a moral universe for its adherents. This is not only about rituals that come with marriage, but the very meaning of these words is different for Hindus, Muslims, Christians, Adivasis, and whole host of communities. It is not just about whether your marriage is a nikah or a 7 feras or I do in a church. Therefore, 1.3 billion people cannot be expected to be governed by a single law. To expect this is to attack pluralism. Pluralism, secularism in the Constitution can be seen in Article 25, 26, 29, besides 14, 19, and 21. This is part of our basic structure. This is what Abdul Ghaffur Nurani once called a mosaic. Our conceptions of a marriage of our family are so vastly different that it is unfair to expect that everyone should abandon it. Just as an example, a marriage in Islam is a contract. As such, both parties can set out any condition they wish to set out. This includes the wife setting out granular conditions on how the income of the household is spent, how the children are raised, and the conditions of what happens after divorce. In contrast, marriage is a sacrament in Hinduism. The very nature of these things is so different that individuals are likely to think of their obligations and rights very differently. It is not fair to force one to concede their understanding of marriage for another. For example, in 2016, the Supreme Court ruled that a wife refusing to stay with her in-laws is cruelty to the husband. Therefore, Supreme Court granted divorce to the man on this ground. In Islam, a woman has a right to separate household, privacy in the same household. Our Prime Minister, Shri Narendra Modi, has long seen our diversity and pluralism as a problem. He sees our distinctions and differences as a major problem to be resolved, which is why he believes in one nation, one election, one tax, one law, one culture, one religion, one identity. So much so that I recently saw that there is also now one nation and one fertilizer. But distinction or differences are not a problem of the Constitution. This is why Article 29 specifically says that any section of Indian society has a right to preserve their distinct language, script, or culture. Differences are to be celebrated. Commonalities also have to be celebrated. This is too complex a point for Mr. Modi, but it is what makes us a great nation. India's legal system must reflect the diversity of the country. One nation, one everything is not something that suits a plural and a diverse nation such as ours. This brings me to the next point, which is that if there is a uniform civil code, Muslims will have to give up on the above mentioned distinctions in favor of a uniform civil code. That will be nothing but a Hindu civil code. All references to Islamic practices will be treated as illegal or unlawful, while all Hindu practices will be protected under law. The best example of this is the Hindu undivided family. In 2015 and 16, the Hindu undivided family tax exemption in income tax costed the Indian exchequer 3,064 crores. The Law Commission recommended that this system should be abolished. Why did the Modi government not do it? Why did advocates of uniformity and equality not campaign for this? In Kerala, Hindu undivided family has been abolished. Has any BJP proponent of UCC ever advocated for the abolition of Hindu undivided family tax rebate? Similarly, Section 21A under Special Marriage Act protects marriages and inheritance between Hindus. But the same is not extended to Muslims. Why? What we see is that uniformity is only equality for Muslims. For Hindus, it is culture, and therefore it is an exception to the law. There is always a Hindu exception to every uniform law. In contrast, in Islam, family is a far more complex system. Property is inherited upon death. While sons have obligations to take care of their aging parents, their wives do not become part of the joint family or undivided family. There is no concept of co-parsoner or karta. Every married couple and their children form a distinct familial unit separate from the extended family. Unfortunately, uniformity is a synonym for common. It is not a synonym for equality. It is not a synonym for sameness. BJP has used a sleight of hand by confusing uniform with common. Furthermore, equality simply does not mean the erasure of distinct cultural or religious practices that are available to each individual. This has significant implications. I want to give some examples of this. One, why are Buddhists, Sikhs, Adivasis, Jain, etc. all clubbed within the Hindu Marriage Act? There have been consistent demands from all these groups that they should not be governed by Hindu Marriage Act. Second, why do Adivasis have a Section 2 exemption the Hindu Marriage Act? Why have they been demanding Sarna code and the right to be identified separately from Hindus in the census? Clearly that their demand does not mean that they are not equals. Their demand does not mean that Hindus are being discriminated against. Their demand simply means the recognition of their distinct culture. A similar case is found for Nagaland and Mizoram under Article 371, which protects their customary rights. Even within Muslims, there are distinct legal schools and practices. Unlike British common law, Islamic jurisprudence is not based on precedent, but on case-to-case basis. The facts of each situation differ, and judges often evolve different solutions. Furthermore, depending on your own school of thought or sect, you have different principles of interpretation. Why should all these be subsumed under the same law? Law in books versus law in action. Most importantly, law is not a vehicle for social reform. If it were, we would not see 80% of child marriages from Hindus. Isn't there a law against child marriages? At least 9 million girls are missing in India as a result of female infanticide from 2000 to 2019. To compare, this is slightly lower than the entire population of Uttarakhand. 86.7% of missing female births are of Hindus, whose population is 79.8%. This is despite a law against female infanticide. National Family Health Survey data reveals that Hindus men who choose to have partners outside of marriage or were in relationship had 2.2 mean number of sexual partners in their lifetime. Sikhs and Christians had 1.9, while Buddhists and Muslims had 1.7 on average. Jains had the lowest mean number of 1.1. The National Family Health Survey 5 tried to find what percentage of men had intercourse with someone who was neither their wife or somebody they lived with. In the 12 months preceding the survey, as many as 7.8% of all participating Buddhist men said yes to this question. They were followed by Sikhs 6%, Hindus 4%, Christians 3.8%, and Muslims 2.6%. Similarly, polygamy is practiced by 1.9% of Muslims, 1.3% of Hindus, a difference of 0.6% despite the fact that it is legal for Muslims and not for Hindus. It is highest among tribals and Christians. Again, despite the fact that it is not legal for either of these communities, the point is simple. It is not the law, it is the social attitudes. Those women who have married partners are not protected by law, but second wives among Muslims are protected and have a right to maintenance. According to census, the percentage of separated and abandoned women is also least among the Muslims, 0.67%, compared to Hindus, 0.69%. Christians, it is 1.19%, and other religious minorities, 0.68%. There are close to 20 lakh Hindu women who are abandoned and separated. This number is 2.8 lakh for Muslims and 0.9 lakh for Christians and 0.8 lakh for other religions. If the goal is gender equality, then one must focus on education, job creation, social attitudes. National Family Health Survey has demonstrated that with an increase in education and wealth, there is an improvement in gender equality. For example, educated and wealthier women are likely to have planned pregnancies. They are more likely to take decisions by themselves. In conclusion, if the goal is to target Muslims and ritually humiliate them, then uniform civil code is imperative. But how far are we going to stretch the meaning of uniformity and equality when we have an Hindu exception for everything, while outlying everything pertaining to Muslims? If despite modern legislation, Hindu men have continued to be bigamous, indulge in extramarital affairs, domestic violence, female feticide, etc., then when it stops with uniform civil code? What is imperative is to strengthen programs that benefit women, that allow them independent decision making, etc. However, it may require actionable policies rather than empty one nation, one everything slogans. The need of the hour is not asking for Article 44, but what about Article 47? Will there be a debate on Article 47? Will the great Arnab Goswami have a debate on Article 47? If an Article 47 debate is started, there will be riots on Friday nights in the streets of Mumbai and Bengaluru and Hyderabad. Let me conclude by saying, by quoting what the late Ram Jethmalani had said. Mr. Ram Jethmalani termed as unnecessary a debate or introduction of uniform civil code in the country and said what the country needed was uniform justice for all its citizens. I thank you very much, Mr. Mahesh Jethmalani, for inviting me to this 17th Ram Jethmalani Memorial Lecture. Thank you very much, Arnab.
Thank you very much. And I'd like to say a few words in response and in summary of what Mr. Owaisi has said. So, Mr. Owaisi, thank you for your challenge, entirely unnecessary. Article 47, which says that the state must raise the level of nutrition, must improve the standard of living, and improve public health. I invite you right now to a debate in the future, which I shall hold, to discuss Article 47 and how the country and all political parties need to work together in that direction. I would like to continue because I would like to continue. I would like to continue.
Please hold on. Please.
I need to respond to some of your points.
Give me 20 seconds. Give me. No. You can do it afterwards. Give me 20 seconds. Give me 20 seconds. Arnab, you must read Article 47 completely, not where it suits you and you stop it. The Constitution of India also talks about the state shall endeavor to bring about prohibition of intoxicating drinks and drugs. Please also say that, Arnab.
Yes.
Please continue. You can now praise me or criticize me. Thank you.
Yes. Now, if you allow me to properly respond to you and see, Mr. Owaisi, it has been some time since I have had the opportunity to prove you wrong on multiple issues, and therefore either you prove me wrong or I prove you wrong, but we should have an occasion to talk to each other. But Mr. Owaisi, I need to just summarize, and this is not a conversation between you and me. It's a much larger conversation that we need to have in this country. My view, however, in summary of your views, is that you are mixing traditions and customs which are fully allowed with legal provisions when disputes reach the court. And anyone with an elementary knowledge would perhaps say that that distinction should not happen. The view of others would be that the Uniform Civil Code is not about killing diversity. It's about bringing consistency so that no one religion, no one gender, and no one community is held back. How one practices their faith is not affected, but that the law applies to them. And when you mentioned the Hindu undivided family, please also keep in mind economic benefits that arise from provisions of the Hindu undivided family would have to be given up if there is a uniform civil code. So you should welcome that as well. However, since this is not an occasion for a one-to-one debate, I think both of us should hold ourselves back, and I look forward to the next time when because it appears to me that you have not been intellectually challenged enough on other platforms, and I assure you that I shall, as and when we meet. But surely Mr. Owaisi is not saying today, Mahesh, that the drafters of our constitution embedded Article 44 in our constitution to kill our customs. Article 44 says that the state shall endeavor to secure in the territory of India a uniform civil code. It's about finding a harmony between customs and modernization to empower our society. So that would be a different perspective, but I think this is the point where we shall stop. This is the point where we shall stop.
That is the rhetorical, Mr. Owaisi. But we'll deal with it at the end of the show.
But it's been enjoyable to listen to him.
It's always a pleasure.
Always a great pleasure to listen to him.
Owaisi on any show.
Absolutely, absolutely. Well, thank you, Mr. Asaduddin Owaisi, for joining us in this memorial lecture.
Thank you.
Which is in honor of the one and only Ram Jethmalani, who is a binding force. We all are bound by our mutual regard and respect for him. Thank you so much, sir. Thank you.
Thank you, sir. Thank you.
Okay, shall we move on to that? It's getting more and more interesting as it moves on, We are holding ourselves back tonight, but I'm sure our viewers are enjoying this. And in fact, I must say that from across the country, I want to share with you, Mahesh, that there's been already a tremendous response from very learned members of the legal community. I would say today the entire country is hooked listening on to these conversations, and therefore I think that the lecture this year is serving its
That's the biggest tribute to Mr. Jethmalani.
Absolutely. Well, let's move on next to another very distinguished guest, shall we, Rhythm, on this third edition of the Ram Jethmalani Memorial Lecture Series. Our next lecture is from Mr. Baijayant Panda, popularly known as Jay Panda. He's presently the National Vice President of the Bharatiya Janata Party. He has been a 4-time Member of Parliament, having served both from the Rajya Sabha and the Lok Sabha. And I've had the pleasure of knowing him well, and I know how passionately Mr. Jay Panda speaks up about national issues that matter. Rhythm.
Absolutely. And Arnab, whether it's economic development, education, information technology, or even data privacy, he has an articulate and rational position on it all. In fact, he's even authored a book called Lutyens' Maverick, which talks about issues like triple talaq and the Uniform Civil Code.
And he has also welcomed, Rhythm, the Uttarakhand government's move to form a committee to draft a Uniform Civil Code, maybe in the same direction as Goa in the state. So there is no doubt in my mind that representing a party whose manifesto promises the rolling out of the UCC, and as someone who has personally studied the issue, he will have a very interesting lecture to deliver. I welcome Mr. Panda to the third edition of the Ram Jethmalani Memorial Lecture. Sir, over to you, Mr. Panda.
Thank you, Mr. Goswami. It's a real privilege and a pleasure to be asked to speak at this third Memorial Ram Jethmalani lecture. I would also like to thank my friend Mahesh Jethmalani for having me speak on this occasion. I had the privilege of serving with Ram Jethmalani in Parliament and have interacted with him very closely. And his outstanding characteristic was that he was outspoken. He spoke his heart and his mind without any hesitation. And in many ways, he was a maverick, and I must say that he was partly an inspiration for my first book, which is titled Lutyens' Maverick. I've been quite inspired by the kind of stands that he took, and he spoke without fear or favor, without regard to how people would receive it. In that spirit, I intend to be very candid and forthright about this issue of the Uniform Civil Code. Now, I would like your viewers to just contemplate for a moment on this aspect, that it's unbelievable that in the 21st century, in fact already into the third decade of the 21st century, in the largest democracy that humankind has ever seen, which is the Republic of India, all citizens don't have the same rights and the same protections. Now just ponder about that for a minute. Now, our Constitution, which is one of the most impressive such documents ever written and widely lauded by everybody, including those who are trying to oppose Uniform Civil Code, it guarantees, in the best traditions of democracy, equal rights to each and every citizen. Now, this is not backed up by all the laws necessary to ensure that each and every citizen gets the same rights, is subject to the same laws, and has the same protections under those laws. This is something our Constitution guarantees, and it's been said ad infinitum, but I think it's worth emphasizing a couple of the articles of the Constitution. Article 44 makes it a duty of the state to secure a uniform civil code for all citizens. The word endeavor means that the state shall try to achieve a uniform civil code. The word endeavor to secure a uniform civil code does not mean that the state will sit back and wait until every last person of the 1.3 billion people are convinced. That's not what it means. Now, Article 15 very specifically points out that there cannot be differential treatment based on religion. You cannot be discriminated against. You can't be given different rights, different protections based on religion. And the lack of a uniform civil code actually does exactly that. It goes against the Constitution. Article 15 is also violated, and Article 51, which insists on gender justice to be given to every citizen. And gender justice is not there when many of our citizens are subject to atavistic laws that are from the Middle Ages or from earlier, and that just does not work. The idea that the same laws should apply to every citizen is fundamental to the idea of a democracy, especially all modern democracies. Other modern democracies don't have such communal laws. And yes, let me point out, having different laws for people of different religion or people of different communities means they are communal laws. So modern democracies have no room for communal laws. You must have one common law for everybody. Now, this is the irony, that many people who claim themselves to be secular are actually batting for the continuance of communal laws. Now, let me give a stark contrast. Just like no modern democracy allows these kind of differential laws for different communities, the nearest example we have of a country that actually provided that in such a manner are theistic countries, not democracies, or not secular democracies. So take the example of the Ottoman Empire, which lasted for more than 400 years and ended about 100 years ago. In the Ottoman Empire, minorities had their own laws within their own ghettos. So in the Jewish ghetto, they had their own laws for marriage, for murder, for rape. But in the overall country, there was a general law, and the majority population of the country were treated like first-class citizens. Minorities who had their own laws in their ghettos were treated like second-class citizens. As soon as they got out of the ghetto, their laws didn't apply. When it came to a clash with the rest of the population on any particular issue, the general law would prevail. Is this what those who want continuance of religious personal laws want? Do they want ghettos of different religious communities who have their own laws? Do they want that the majority population of the country should be treated as first-class citizens and the others should be treated as second-class citizens? So this kind of hypocrisy has no place in a modern democracy. Now, India's communal laws, different laws for different communities or different religions, is a colonial legacy. And this colonial legacy was based on the principle of divide and rule. India was not a democracy then. We did not, under colonial rule, have equal rights for each and every citizen. The whole principle was based on divide and rule. Now, when we got independence in 1947, there was enormous chaos. There was violence, and the country was partitioned with a huge number of deaths and displacement. And in that situation, the founding fathers and the founding mothers of the Constitution of our Republic of India, they made it very clear that this being a subject where the whole country was divided on the issue of whether different religions can live together or not. So they postponed the issue but made it very clear in Article 44, which is a directive principle that we must have uniform civil code. Now, postponed doesn't mean cancelled. And here is a very sensitive matter that we must actually confront. You see, why was the country partitioned? It was partitioned because a number of people disagreed with the idea of a modern democracy where every citizen has equal rights, where every citizen has one vote. They said they could not live like that. They did not accept that India was one country. And therefore, they insisted, they created violence, and they partitioned the country. And they got their own country. Those who don't believe in our type of country, that we are a democracy where every citizen has equal rights, equal obligations, equal protections of the law, and the same law applies to everybody. Those who didn't believe that, they figured that they couldn't live in this country where the majority population is Hindu, and so everybody having equal rights and everybody having the same vote, they could not live with. They went away, they formed their own country. And those who today claim that you can't have one law for 1.3 billion people are making the same argument. They are making the same argument that India is not one country and that different sections of the population need to have different laws. And that is just not acceptable. That is not how this country was founded into a republic. It goes entirely against that principle. Now, I will round off, and before I conclude, I want to address some of the other objections that some of the opponents of universal uniform civil code are making. Some of them are saying that this is against their right to practice religion, but that's rubbish. You mean to say that in other democracies, in America, in Germany, in the UK, in France, in Japan, in Australia, you mean to say because they have the same laws for all citizens, people of different religions can't practice their religion? So that's just a straw man argument. Some people are actually going to the extent of saying this is against the Constitution. Now that's bizarre when there is a very specific point in the Constitution article which says that we must endeavor to achieve this. Now, some arguments are being made that why aren't other directive principles of the Constitution being implemented? Why aren't some other rules which apply to some sections of the population being changed? Now, this is a whataboutery argument, meaning that either you achieve all the objectives at the same time or you don't achieve any objective. That's actually, I don't want to sound too harsh, but that's actually a ridiculous argument, that you have either all or nothing. The reality is that the perfect cannot be the enemy of the good. Having a uniform civil code is not only good, of all the pending matters in the Constitution, this is the most important because it applies to the largest number of citizens. It applies to the largest number of citizens who today do not have the same rights, the same law, and the same protections. There are some arguments that it should be voluntary. Yes, some of the founders said that perhaps to ease into it, you could have an initial period of voluntary, but you can't have laws that are voluntary forever. That's not how countries function. That's not how constitutions function. Adherence to laws cannot be optional. They need to apply to everybody, decided in a democratic manner. The argument that UCC will be a Hindu law is terrible argument to make. It's just trying to foment dissension within society. That's not the case. In fact, laws for Hindus got changed first of all as soon as the Republic was formed, and I think that has set the right precedent that we should have changes for all communities so that every Indian citizen is first and foremost an Indian, and only after that he or she is a Hindu or a Parsi or a Muslim or a Christian or Sikh, just like it is in democracies anywhere in the world. And I think this government has proved its credentials, with our motto of Sabka Saath, Sabka Vikas, Sabka Vishwas, Sabka Prayas. I keep citing this example that there are hundreds of union government schemes which apply to hundreds of millions of Indians across the country. And you cannot find a single example of discrimination. You cannot. So the track record does not show that there is any intent to create discrimination. The intent is to truly take India into the 21st century, to truly achieve the fundamental objectives of a democracy, of a modern democracy, of the largest democracy that humankind has ever seen, and achieve the most important of the directive principles of the Constitution. This is not to say that other directive principles should not happen. Let them happen, but each has to be taken on its own merit. This is the one that impacts the most number of citizens of India, and it is high time now that we have a uniform civil code. Thank you. Jai Hind and Jai Bharat.
Well, thank you very much, Mr. Jay Panda. Listening very closely, a couple of thoughts, you've talked. I think you were very fantastic when you said that some people feel you should ease in the change, but others would argue that you can't ease in the change. Some change has to happen suddenly, like 370. When the government abolished 370, you couldn't have eased in that process. When you ease in, when you try and make it voluntary, when you live in that kind of gray zone, that could end up becoming more dangerous. And I think this, you've taken forward the argument about what can social customs mean. If social customs deny equality, should these social customs be allowed? If social customs are against gender justice, should they be allowed? There are some cases we were reading where in some tribes in India, women are denied land rights if they are victims of rape. And where a widowed woman can only live on subsistence provided by the available next male relative. They have no rights on ownership of land. So I think if social customs are so antediluvian, they should be made to go and not go away easily. They should be made to go fast. But that was fascinating, and I'm sure that your arguments will propel the debate forward, and I'm sure that when this debate comes in Parliament, and I'm saying when and not if, when that debate comes into Parliament, you are going to be right there on top of that debate. Thank you very much, Mr. Jay Panda, for joining us. Thank you very much indeed. And that takes us, ladies and gentlemen, Jay Panda there. And that takes us to our last speaker today, Mr. Jethmalani, as part of this wonderful lecture series. It's my privilege to welcome an academic, a legal scholar, and an educator by profession, Professor Faizan Mustafa, who will be delivering his take on the pressing question and theme of this Ram Jethmalani Memorial Lecture Series: has the need for a uniform civil code become an imperative today? Professor Faizan Mustafa has held the position of Vice Chancellor of the esteemed National Academy of Legal Studies, NALSAR, in Hyderabad for a decade. Rhythm.
Absolutely. And Arnab, under Professor Mustafa as the Vice Chancellor, it was ranked as the #1 university for legal studies in the country. Besides researching, teaching, he's also authored several books, several papers. In fact, his article on religious freedom was quoted by the Supreme Court in the Sabrimala judgment in 2018.
Absolutely, it was. And he had written in the past on his belief that the path to a uniform civil code comes not from a complete rehaul but quote-unquote piecemeal reform. We'd like to know what that piecemeal reform can be. He sees the issue, I think he feels, from a practical, pragmatic lens of societal and administrative feasibility. I have no doubt that his lecture on the issue will be studied, scholarly and truly nuanced. Professor Mustafa, welcome to the third edition of the Ram Jethmalani Memorial Lecture Series. Over to you, sir.
Thank you very much, Arnab. And I'm really grateful to Mahesh Jethmalani ji for inviting me for this prestigious debate. I met Ram Jethmalani way back in 1993. And as the luck would have it, when I was given the Best Law Teacher Award, Ram Jethmalani also got an award and he made a wonderful speech there. So Arnab, you are right. I am for Uniform Civil Code, but I am not in one go doing a Uniform Civil Code. I have been writing that the only way is to go for piecemeal reform. And piecemeal reform will mean that small doses of reforms in a series of legislations would be a much better option. And why I'm saying so, because what really happens that ultimately we should not, in the process of enacting a uniform civil code, fall in the trap of communalists and fundamentalists. I had written a piece in favor of Uttarakhand Chief Minister's initiative of setting up the committee to draft a uniform civil code. But I'm absolutely disappointed to see the composition of the committee, because committee has officers and bureaucrats. It does not have experts. It does not have experts of personal laws. And that is not the way to go about. Some of the earlier speakers referred to the Constituent Assembly debates. As someone who has taught constitutional law for over 3 decades, I would like to say that our obsessive insistence on uniformity as against social justice and women's rights is the problem. If you look at the Constituent Assembly debates, its 3 main proponents, Alladi, Munshi, and Ambedkar, sought to justify uniform civil code provision in terms of national unity and not in terms of women's rights. So what Ms. Diwan was saying, it was not from the perspective of feminism. Similarly, I believe that cases like Shah Bano or Sarla Mudgal, where judges came on heavily against the government for not doing enough in terms of implementing the directive principle of uniform civil code, I believe they damage the cause. Ultimately, it is a policy decision, and a policy decision should come from the government rather than from the court. Now, the legitimacy of the case for uniform family laws driving from a monolithic view of nation state with not only a single polity, but also a single culture is questionable. It undermines, rather repudiates, the pluralist model of a liberal democratic state, where cultural autonomy is ensured to all religions, ethnic, and other groups of people constituting that society. Its assumption of uniformity of family laws as a sine qua non of nationhood can also be questioned empirically. From the example of the United States, where multiplicity of family laws, especially on divorce, and even of criminal laws, varying from state to state, do not come in the way of cohesiveness of a state as a single political nation. Now, the UCC debate, and that is tragic, it strengthens the majoritarian chauvinism on the one hand and minority fundamentalism on the other. And that is the reason I have suggested that let us reform in small doses. For instance, the government recently increased the age of marriage for girls. Now, this is a reform which will be applicable to everyone. So that is the way to go about. I believe that the Uniform Civil Code, like the cause of Hindi as a national language, has suffered due to the over-enthusiastic espousal by its crusaders. I am all for the just code. And that's why I have written number of times that just code is far more important than the uniform code. Different communities may have different laws, but all such laws must be consistent with the constitutional provisions and ideas. Even the Hindu code bill could not be passed as one single law. We have 3 different laws under the Hindu code bill. Similarly, there was some talk, some mention that the British started it. This is not right. In fact, the exemption from state laws was the policy of Delhi Sultanate rulers and Mughals, and the British merely continued it. Now, there was a reference made that how come the mercantile law and the criminal law can be less important than personal law. There is a point, but if a state enacts uniform civil code, no one can do anything about it. Moreover, I always believe that normative changes in law do not bring about a social reform. So Hindu Succession Act, Arnab, was reformed. Of course, initially we could not give daughters a share in the co-parsonary. We could not make her co-parsonary. It took many, many decades. It was only in 2005 that daughters became a co-parsoner. But look at the women ownership, Hindu women's ownership. What the facts are telling us, that they are not getting the share which they are entitled to as per the Hindu code bill. And why this is happening? Because the same law is permitting people to make will. Now, if I have a daughter and I have a son, and I make the will of my entire property in favor of my son, my daughter will not get anything. So that's why just mere change in law is not going to really help. There was a reference made about land laws. I think this is important. Arif Bhai also made some reference to this. You see, when we passed the Shariat Application Act, and this is the hypocrisy of Muslim clergy and Muslim leadership, it exempts agricultural land. Of course, they can say that the Shariat Act is a federal law and agriculture is a state subject. That's why it was not covered. But basically, the effect is that Muslims through Shariat Act have deprived Muslim daughters from their share in the agrarian land. Now, the Zamindari abolition laws, which we passed in number of states after the commencement of the constitution, and we included it in the 9th schedule and therefore protected it from the challenge in the courts, it also denies women, share in the property in the agrarian land, because there we said that, there should not be fragmentation of land, but it goes absolutely against the principle of equality. I would also like to say that legal pluralism as such is not inconsistent with national integration, and hence to argue for uniformity on such ground is indeed against the spirit of pluralism. What I am trying to say that if we want to really create the conducive environment for uniform civil code, we must popularize this idea that be it Hindu law or Muslim law, it is a jurist given law. The entire Muslim law was developed several centuries after the Prophet of Islam by the Muslim jurist. And since just like Roman law, Hindu law and Muslim law are jurist given laws, they are not sacred. And if they are not divinely given laws, then there will not be much resistance to reform. I have said it a number of times that Quran is not a book of law, but it is a book of principles. Of about 7,000 verses in Quran, you have only about 200 books about law. Our judges also read Quran as if it is a statutorily enacted law, which again is wrong. So the other thing I would like to say that gender justice cannot be brought only through the instrumentality of law. Maybe we need to do something more to bring about the gender justice. I have also written a number of times that for effective law reforms, we must take ulama on board, because they are the ones who had done this great disservice to the cause of Muslim community by not initiating much needed reforms in Muslim personal law. And since they are the one who control the pulpit of mosque, I don't control the pulpit of mosque. unless they are with us in terms of reforms, it would be very difficult to bring meaningful reforms. Even a man of Duncan M. Derrick's stature, who was a great jurist of both Muslim law as well as Hindu law, this is what Arnab he had to say, and I quote, "The best way to reform Mohammedan law is not to reform it at all. Let its inconvenient and archaic features wither away. Once it is accepted that this is the policy, it will wither away fast enough. If there is a frontal attack on personal law, it will survive with the tenacity it has been unable to show in countries where the majority of population are and always have been Muslims." Unquote. Arif Bhai also referred to an interview, very interesting interview from Govalkar ji about Uniform Civil Code. But he referred to just one question. This is a 26 August 1972 organizer interview. And I would like to go to some of other questions as well, because if you go to cases like Sarla Mudgal, again they said that Uniform Civil Code will bring about a national integration. Now, the question was like this: you don't think that a uniform civil code is necessary for promoting the feeling of nationalism? The answer by Guru Govalkar was, I don't. This might surprise you or many others, but this is my opinion. I must speak the truth as I see it. The question was, don't you think that uniformity within the nation would promote national unity? Answer from Guru Govalkar was, not necessarily. India has always had infinite variety. And yet for long stretches of time, we were a strong and united nation. For unity, we need harmony, not uniformity. Unquote. I believe that the whole point which is being made is that it is there in the constitution and we must implement it. So the question was put to Guru Govalkar. That is all right. The question was like this: the state is charged with the duty of securing a uniform civil code for citizens of the country. A beginning has to be made if the constitution is to have any meaning. This was the question, Arnab. The answer was, that is all right. Not that I have any objection to a uniform civil code, but a thing does not become desirable just because it is in a constitution. In any case, our constitution is a hodgepodge of some foreign constitutions. It has not been conceived and drafted in the light of Indian experience. Then there was a question about this whole uniformity of criminal laws. By the way, once I had spoken on NDTV that at least the criminal law is uniform. And then next day when again I was there, I had to answer a question that number of states have brought in amendments in Indian Penal Code as well as in Code of Criminal Procedure. So in some states you will have anticipatory bail, in other states you will not have anticipatory bail. Now this is the answer from Govalkar ji. There is a difference between the two. The civil law concerns mainly the individual and his family. The criminal law deals with law and order and 1,000 other things. It concerns not only the individual, but also the society at large. Arnab, I would believe that personally, no country can say that we will not reform our laws. All laws do need a reform. The only question is, how do we go about the process of reform? I believe any reform which is imposed in the top-down model may not work. If you look at the Hindu Code Bill, when it was introduced, out of 27 speakers who spoke, 24 opposed it. RSS opposed it. Hindu Mahasabha opposed it. Ambedkar had to resign. There were people who said on the floor of Lok Sabha that Ambedkar, being a Shudra, is taking a revenge from the caste Hindus, and Nehru had to make compromises. 1941, Hindu Law Committee was constituted. 1955, we were able to enact laws. Where is a Muslim law expert committee? Where is a blueprint of uniform civil code? Directive principles are not directed to citizens. They are the obligations of the state. It is the duty of the state to constitute an expert committee which will look at all the reforms which are needed to be done. And once that committee has submitted the report, we have to go back to Hindu Law Committee again, because number of reforms in Hindu law are to be done. For instance, if there is an IAS officer couple, a Hindu issueless IAS officer couple even today, and they die, the property of the husband will go to husband's parents, and the property of the IAS officer wife would also go to in-laws rather than her parents. There are a number of changes which are to be made even in Hindu law, and therefore their consent would be required. If we are really serious about uniform civil code, we should constitute committee of independent experts who don't have, opinion on this side or that side. And then these independent opinions will have the much needed respectability in the society, and it would become much easier for us to move forward. I think that is what we need to do. But if you look at how courts have looked at it, even in Sarla Mudgal, where 4 women sued for bigamy. Now they have gone to the court because their Hindu husbands had converted to Islam, and they are the ones who are challenging it. Now the court is not saying anything about these people. The court is going about Muslim law and saying that the Muslim law permits this kind of thing. I believe that the kind of statements which came from the court, that we made a choice and those who rejected the two-nation theory would stay back and no community could claim to remain a separate entity on the basis of religion, it was not necessary. It was not necessary. If we really want to bring a uniform civil code, we first of all must have expert committees of different personal laws, because good features of all personal laws are to be incorporated. For instance, Muslim marriage is a contract. Are we willing now to incorporate this in the uniform civil code? Are we going to, give up the whole idea of Kanya Dan? Now, Dan is not considered good because Dan is gifting away something, some commodity. Are we willing to make changes in law of will? I just told you that even though the Hindu Succession Act gives an equal right to son and daughter, but the father can always make a will in favor of the son. The Muslim law says that you cannot make a will in favor of any heir, and you cannot make a will of more than 1/3 of your property. So give and take of different personal laws has to happen, must happen. We must move towards a just code, and just code, I believe, is far more important than a uniform civil code. There is nothing in this word uniform. If you look at the whole constitution, Arnab, look at personal laws as a subject is in the concurrent list. Therefore, the framers of the constitution thought that both state and the center can enact law on personal law. That's why Uttarakhand government, I had written in my article in Indian Express, was well within its right to constitute a uniform civil code committee. So if the framers of the constitution are putting personal law in the concurrent list, that means that they are not going ahead immediately for a uniform civil code. The crucial word is endeavor, a sincere endeavor. Whether there has been that sincere endeavor or not, my answer is that that sincere endeavor has not been there. And here is the right time now that we try to convince people about the importance of gender justice and make all laws compatible with the constitutional vision. Thank you very much, Arnab, and thank you very much, Mahesh ji.
Well, thank you. Thank you, Professor Faizan Mustafa, and it is very fitting. I think your observations at the very end of this wonderful memorial lecture series, you've actually presented all perspectives. You presented both perspectives. You are not an opponent of the Uniform Civil Code. You are trying to nuance a process for it because you believe a balance needs to be made on the nature of the process, right, and the need for a Uniform Civil Code. So this is another very fascinating, absolutely fascinating dimension. And I think it's very important because, you know, there are so many acts. Hindu Marriage Act, Hindu Succession Act, Christian Marriage Act, Indian Divorce Act, Parsi Marriage Act. These are all laws regulating adherence of different religions for personal laws. Now, Muslim personal laws are different. Because Muslim personal laws, Professor Faizan, are not codified. They are based on an understanding of the religious texts. And so the politics comes in and therefore people take advantage of this. But yours has been a very, very, very nuanced perspective, Professor Faizan Mustafa. I'm sure that as this debate progresses through this year and the next, presumably, you will be a strong participant in all our debates. I thank you. It's been a privilege to have you speak tonight. And in conclusion, I want to... Yes. Yes, okay, okay. Okay, I correct myself on that.
It is like triple divorce act. So there are laws which deal with the personal law, Muslim personal law as well.
Okay, parts of it are codified, yes. Okay, but parts are not, and based on religious texts, which makes the debate on this very complex. But thank you very much once again, Professor Faizan Mustafa. Thank you very much, sir. Thank you. And viewers, I want to just say a couple of things at the very end here, if I may, and then I want to hand over fittingly to Mahesh Jethmalani, who has been kind enough. He's listened through the whole thing, and he says he'll respond at the very end. I have enjoyed this personally, greatly. We all have, because first of all, this has been in memory of Ram Jethmalani, who we love. When people share their expressions and views towards different people and emotions, about Ram, we say that we love him. And he was, in his own words, an unrepentant maverick. And he was an absolute contrarian. He would have loved this conversation today, because he would have loved the contrarian perspectives which have emerged. And he would have listened, and I feel he would have jumped in, he would have lunged in, and he would have come back. And if he was sitting here, we'd have to pull him back. And he was that kind of a person, Mahesh. Whenever I had an interview with him, you know, sometimes he would say at the end, "You didn't provoke me enough." And then he would get very angry during the debate, during the discussion. And then before leaving the studio, he would say, "I need to cool down. So get me a sandwich and a cup of coffee, and I need to cool down. I need to have a chat." So, but he was just a lovely person. And the whole country, the Prime Minister, led in paying tributes for him. What a fascinating person. And it is, I want to thank you, Mahesh. I want to thank you from the bottom of my heart, at a personal level, for giving us the honor of allowing us to be the platform to host a lecture in his honor that you have done painstakingly every year. Your thoughts, please, at the very end. Mahesh.
Thank you, Arnab. Thank you, Arnab, for providing such a good platform for the lecture series. Your viewership is well known, and therefore the outreach of this event improves leaps and bounds.
Thank you.
You know, I pin my ideological flag firmly to the masthead of a uniform civil code being imperative. Briefly, the arguments against have emanated from Justice Kurian Joseph, of course, Owaisi, and to some extent, Faizan Mustafa. Now, as far as Justice Kurian is concerned, his argument basically is that, you know, there are many other directive principles. Why focus on 44? He quibbles with the word imperative. He says it's not imperative. There are more imperative directive principles which should be implemented. He mentions particularly 37, 38, 39, 46, 47. But these are all welfare directive principles. They are geared towards welfare. And as Madhvi pointed out in her lecture, all governments, we don't have to be political about this or invidious, all governments have tried to implement in varying degrees and with varying degrees of success these welfare measures which our Constituent Assembly has injuncted us to follow. So the point about Article 44 is it is imperative because it is doable. It is doable and it is necessary given our times. Our times are fractious. Every little issue pertaining to personal law, and actually on the fringes of personal law, say hijab, the hijab issue, are now being dragged to the Supreme Court and consuming a lot of time that court which could be devoted to more serious issues. It is the lowest hanging fruit. Article 44 is doable and it's the lowest hanging fruit from all the directive principles. It is a matter which promotes gender justice. As Madhvi put it again, it constitutes essentially a feminist agenda. The section of society oppressed historically, apart from those mentioned in Articles 15 and 16, that is the scheduled castes, scheduled tribes and the OBCs, are women. It is time now we turn to redressing their historical injustices in matters of divorce, alimony, succession. It's time we brought them on par, because 50% of this population consists of women. 50% of India consists of women, and the more we empower them, the more we empower the nation. We free them from the shackles of the past and allow them to be productive citizens in this country and add to our wealth and our prosperity. The other argument is Asaduddin's. First, he says that diversity is destroyed. Now, first of all, nobody is talking about destroying any religion. And there's a distinction between religion and personal law. It is only the essence of every religion that is to be preserved. And even those essences of a religion, or proclaimed essences of a religion, depending on your textual interpretation, only those essences are to be discarded in a uniform civil code which violate constitutional morality. And this is not directed at any particular religion. The victim card played by Asaduddin is most unfortunate. It's not correct. Hindus too have had some of their religious practices curtailed. Take the Sabarimala case. That case was decided on the test of constitutional morality. The Supreme Court upheld the right of women. Again, a question of gender justice in the case of Hindus. The Supreme Court upheld the right of all women at all times to enter that temple, and it was done on the principle of constitutional morality. So also, the Uniform Civil Code will ultimately discard the pernicious practices of all religion, enhance equality, particularly for women, and it will be done on the touchstone of constitutional morality. This is not against anybody's religion. This is to upgrade our civilizational values, to bring it on par with decency and humanity. And that is why it is an imperative. As far as Mr. Faizan Mustafa is concerned, he's not an opponent of the Uniform Civil Code. His is a more nuanced approach. But he pleads for time. He says that we must wait, we must bring all stakeholders. But we are 75 years down the road from independence. Our forefathers, our ancestors, giant men who framed our constitution, said that the state shall endeavor from 47 onwards, or 1950, when the constitution was first adopted. From the very beginning, outset, they should endeavor to enact a uniform civil code throughout the territory of India. That, unfortunately, has not happened till today. The biggest victims, as I said, are the women of this country. Tell that to them, that you must wait for some more time. Wait for your legitimate rights to succession, to alimony, to property, etc. Wait your time. That is really what Faizan Mustafa's plea boils down to. In any event, ladies and gentlemen, the time now has finally come when this debate should end. As I said, we must hasten justice. And I would like to quote ultimately, and this is really from our forefathers, this is from K.M. Munshi, and it bears reading out. This is what he says regarding the Uniform Civil Code. We are going to consolidate and unify our personal law in such a way that the way of life of the whole country may in the course of time be unified and secular. Please note the words. The way of life in this country may be unified and secular. We want to divorce, again, please note these words. We want to divorce religion from personal law, from what may be called social relations, or from the rights of parties as regards inheritance or succession. What have these things got to do with religion? I fail to understand. After all, we are an advancing society. This is 1950. We are in a stage where we must unify and consolidate the nation by every means without interfering with religious practices. If, however, the religious practices in the past have been so constrained as to cover the whole field of life, we have reached a point where we must put our foot down and say that these matters are not religion, they are purely matters for secular legislation. That is what is emphasized by the article, i.e. Article 44. On that note, on that very profound note from K.M. Munshi, speaking for the Constituent Assembly, I rest my case for the subject of today's discussion. Thank you, ladies and gentlemen. Thank you, Arnav.
Thank you.
Thank you, Rhythm.
Well, it has been our pleasure. Rhythm, me, our entire team here to host this. This has been, viewers, a 3-hour non-stop. It's one of our longest uninterrupted broadcasts. I hope you've enjoyed it. And I hope that you do feel that with debates like this, the role of the media in sparking a debate which can change the history of our country would have been achieved, at least as a small step. We all pay tribute to Ram Jethmalani and look forward to hosting once again the next edition of the Ram Memorial Lecture Series. Viewers, snippets from these conversations will be available on republicworld.com. We shall update you about that as well, so that the conversation has a longevity beyond today's event. Thank you very much, everyone. From all of us here, thank you for watching and goodbye.
Fulfill your dream of studying at the world's leading universities, and that too at a reduced cost with Amity's Global Study Program. Study in India with Amity for some years. Then take a transfer to leading universities in the USA, UK, Canada or Australia and earn a foreign university degree. Apply at amity.edu/global study.
There's a very famous saying in Pakistani Punjab, Khanda Pita Laheda, Baki Ahmad Shahida. Whatever you eat is yours, and everything else, including the clothes on your body, belong to Ahmad Shah. This is the truth of what the invaders did. But Pakistanis would celebrate those invasions because that is what they wish to be, is something that has deeply scarred the Pakistani mindset, not knowing who they are, not knowing where they are going. Any society, any nation without a compass, without a sense of direction is bound to fail.
The third edition of Ram Jethmalani Memorial Lecture Series. Has the need for a uniform civil code become imperative today? Honorable guest speakers Shri Arif Muhammad Khan, Justice Kurian Joseph, Shrimati Madhavi Goradia Diwan, Shri Asaduddin Owaisi, Shri Baijayant Jay Panda, Shri Faizan Mustafa. The third edition of Ram Jethmalani Memorial Lecture Series, 17th September from 5 p.m. to 7 p.m. only on Republic TV.
भारत की भूमि से 2024 तक कुछ भी हो, we will create a global news organization from the soil of India.
जो राष्ट्रीय चैनल वो क्षेत्रीय और अंतरराष्ट्रीय बिल्कुल दोनों दिशा में आगे बढ़ दोनों दिशा. You may be one of the channels which is a national channel going regional and international both at the same time. My best wishes to you and your group.
सीए से प्रॉब्लम क्यों नहीं है? आसाम के लोगों के लिए बांग्लादेश के लोगों का आना वो इशू था, यानी कि विदेशियों का आना इशू था, ये नहीं कि वो हिंदू है कि मुसलमान है।
वर्ल्ड में, विश्व में, जहां में भी हिंदू है, भारत उनका जननी है, भारत उनका जन्मभूमि है। जी। एंड इफ यू आस्क हिंदू नॉट टू कम टू इंडिया, वेयर दे विल गो? सो भारत का ऐतिहासिक दायित्व है, जो अखंड भारत में हिंदू रहता था, you cannot term them as a Pakistani and Bangladeshi. They are Hindu, they are proud Hindu. They are India.
The most renowned speakers, the most acclaimed legal eagles, the most distinguished academicians, and the biggest newsmakers come together on the most esteemed stage. Watch the unmissable Ram Jethmalani Memorial Lecture on September 17th only on Republic TV.
हिमंतो दा, पहला सवाल आपसे यह है, हर दिन आप सुर्खियों में रहते हैं या हर दूसरे दिन आप सुर्खियों में रहते हैं, कभी कुछ कहते हैं, कभी कुछ करते हैं, कभी कोई आपके खिलाफ बोलते हैं, और ये वाड्रा कांग्रेस के साथ तो आपका पुराना रिश्ता था और लग रहा है कि वो छोड़ना भी नहीं चाहते। हर दिन आप पर वो कमेंट करते हैं, आप पर ट्वीट करते हैं, या तो उनका दिन शुरू होता है खत्म होता है आपके नाम को लेकर। कभी आप ये जो अवैध मदरसे हैं उन पर आपने बुलडोजर चला ली तो उस पर बातचीत होती है। तो हमने नोटिस किया है कि लोग वैसे मुख्यमंत्री बनने के बाद सुर्खियों से हटने की कोशिश करते हैं, कहते हैं अभी हमको पीसफुल नॉन कंट्रोवर्शियल एग्जिस्टेंस चाहिए। हिमंतो बिस्वा शर्मा पर ये रूल अप्लाई क्यों नहीं होती? हिमंतो दा, आप हमेशा सुर्खियों में क्यों रहते हैं, ये कैसे हो रहा है?
नहीं, पहला बात, मैं सुर्खियों को रहने में मैं प्रयास नहीं करता हूँ, लेकिन जो मैं काम करता हूँ आपको लगता है कि वो सुर्खियों में होना चाहिए, तो इसलिए आप लोग मुझको सुर्खियों में लेके आते हैं। मैं सुर्खियों के लिए कुछ नहीं करता हूँ, जो मन में आता है वो बोल देता हूँ बस।
तो आप सोचते नहीं है मन में आया तो मगर मैं कहूँ तो इस पर क्या प्रतिक्रिया होगी?
नहीं, मैं खाली मैं इतना ही देखता हूँ कि मैं कुछ बोलता हूँ, जब कांग्रेस वाला लोग ट्रोल करता है तो मैं इतना ही देखता हूँ कि आज ट्रोल उनका 500 हो गया कि 600 हो गया, कितना को कर पाया मोटिवेट, मैं वही कभी कभी देखता हूँ, उसका आगे कुछ नहीं देखता हूँ।
आप नहीं देखते? तो मूल मुद्दे पे आ जाए, जो अभी का हॉट मुद्दा है। राष्ट्रीय सर्वोपरि के सम्मेलन में कंट्रोवर्शियल मुद्दे भी हैं। आप आजकल पिछले 3 हफ्तों से आप हेडलाइंस में हैं कि आपने अवैध मदरसों पे बुलडोजर चला दी, और वो जो विजुअल है कि अवैध मदरसों पे बुलडोजर हिमंतो बिस्वा शर्मा ने क्यों चलाई? कहा जाता है क्या हिमंतो बिस्वा शर्मा न्यायपालिका को नहीं मानते? क्या न्यायिक व्यवस्था नहीं है? क्या ये योगी वाला अप्रोच है? मनमानी कर रहे हैं या फिर किसी लॉबी के लिए कर रहे हैं? तो इस पर आप जरा, आज पहली बार आप दिल्ली में आए हैं ये पूरे कंट्रोवर्सी के बाद, तो जरा इसको आप एक्सप्लेन कीजिए कि आपने ये अप्रोच क्यों ली, इसकी जरूरत क्या थी?
अर्नब जी, 2-3 बात आपको थोड़ा सा असम कॉन्टेक्स्ट में देखना पड़ेगा
जी।
असम में हमने अल कायदा का मॉड्यूल हमारा हाथ में पकड़ा गया। जब हमने ये मॉड्यूल का पीछे पढ़ा तब हमको ये भी खबर आया कि सेम मद्रासा में दे हैव एस्टैब्लिश देयर नेटवर्क, उनका कार्यालय बना, ऑफिस बना, तमाम सारे गड़बड़ी काम
किसका
हुआ।
कार्यालय बना?
ये हुआ जो हमारा एबीटी बोलता है, अंसारुल बांग्ला टीम है, जो बेसिकली आईएसआई का, ये जो बेसिकली अल कायदा का इंडियन सब कॉन्टिनेंट का एक एलाइड ग्रुप है।
उसका नाम है अंसारुल बांग्ला टीम
जी। और नॉर्थ ईस्ट और बंगाल में एबीटी ही ऑपरेट करता है
जी।
जब उनका मॉड्यूल हमारा पास आया, पकड़ा गया, हमारा नज़र में आया कि दे आर ऑपरेटिंग फ्रॉम मद्रासा। अभी मद्रासा किसके लिए होता है? कि आपको कुरान का शिक्षा देने के लिए मदरसा होता है।
जी जी।
मदरसा तो जिहाद करने के लिए नहीं होता है।
जी।
द मोमेंट ए मदरसा इज बीइंग यूज्ड फॉर एबीटी और फॉर जिहाद, दैट मीन्स इट्स लॉस कैरेक्टर ऑफ द मदरसा। उसका आगे और मदरसा वो नहीं है। तो हमने उनका पब्लिक को जाके बात किया, देखिए ये तो अभी मदरसा नहीं है, ये तो अलकायदा का कार्यालय बन चुका है, आप इसको रखना चाहते हैं? नहीं साहब, तोड़ देना चाहता हूँ। तोड़िए।
किसने कहा आपको तोड़ देना?
पब्लिक ने तोड़ा है।
नहीं नहीं, पब्लिक ने नहीं तोड़ा।
पब्लिक ने तोड़ा।